Hello, everybody. We're going to get started. Hello. And thank you for coming. This is going to be our legislative and case law update. We will start with the legislative update. But I'm Steve Jensen, Chief Deputy District Attorney, and assisting me is Colleen Ward, and she is a Deputy District Attorney. She is assigned to our appellate section. And so we've broken this up together, and there is some materials up here. One is a handout booklet. The other is a case law summary, and then there is a review form. If you get a booklet, you have to sign in. And Allison, okay. And that's for CDAC, because we have to give these things back to CDAC, and then they get booklets paid for by the legislature, I think. And so just follow the money, and then you'd understand, and then we all understand it all. So copyright notice, wonderful. Some housekeeping things. We already talked about signing in, breaks. We will go through the legislative update first, then we'll take a break, and then we'll go through the case law update. Hopefully we'll be done before 5, but we will see. And edits and corrections. There are a few edits, corrections, and omissions. You want to go over those, Colleen?
Yes, we can do that. First, on page 2, it says that the Honorable Beth McCain is in the 1st Judicial District. That is actually incorrect. She is District Attorney for the 2nd Judicial District. Then, if you turn to page 15, let me get there. This one is in the actions related to competency to proceed. Page 15, 4th bullet point from the top. It says for Class 4 felonies, VRA Class 5, and 6 felonies, excluding sexual crimes or crimes of violence, the court may dismiss once the defendant has received competency restoration services while confined for 3 years. That should actually read 2 years there, not 3 years. So if you could make that note. And then, if you turn to page 29, this one is organized retail theft prevention, and it'll be in the 2nd bullet point from the top. They have the penalty incorrect here. Instead of being a Class 3 misdemeanor for a first offense, Class 2 misdemeanor for a 2nd or subsequent, that should actually read a Class 3 misdemeanor for cards valued over $30. And a petty offense for cards valued under $30. And then if you turn to page 61, this is for juvenile record expungement cleanup. This will be in the 4th bullet point from the top, 2nd line. And it's just grammar issue. It says issues, they issue sentences, it should just say issue. And the final one, and if I'm going too fast, please let me know. The final one is on page 88. And this is in the 5th bullet point. It's a sentence right before you get to kind of the open bullet points following. It says, establishes that when a law enforcement officer coordinates a telephone or video interview between an individual in custody of federal immigration authorities, that officer must advise the individual. It should say the officer must advise the individual in writing. That is the final edit for the book this year.
So, a little overview in terms of the legislative session in 2019. There were a number of significant changes. Of course, there was an election, and Jared Polis was inaugurated as Colorado's 43rd governor. But in the House and in the Senate, things did not go well for the Republican Party. And so there's a new president of the Senate, Leroy Garcia. He's from Pueblo. And Casey Becker was elected Speaker of the House in the House. And whereas the House majority is now a very lopsided 41 to 24. And last year in the Senate, there was a 18-17 split, 18 Republicans, 17 Democrats. Now there are 19 Democrats and 16 Republicans. And so the result of that means that for the first time in a number of years, we have single party leadership and control of the entire lawmaking process in Colorado. So probably some of these bills you will see will reflect that. And I've heard him say this a number of times, that probably the environment that's downtown now is probably the most anti-prosecution and anti-law enforcement that he has ever seen in his career. And if we want to get a bill passed, we've been told that it has to be first approved by the Public Defender's Office and the ACLU, or it's dead on arrival now at the legislature. I'll give you an example of one which I thought was a relatively straightforward bill that I wrote. I'm the chief of Gilpin County, and up in Gilpin County, our limited gaming district, we only have 6,000 people in the county, but we have an inordinate number of criminal offenses, and we only have a part-time judge and a part-time county court judge and a part-time district court judge. That's translated into a lot of congestion and games playing, because you only have a judge that's going to give you one trial day, maybe 2 trial days a month in county court, and in district court you have 1 trial week a month. And I filed 328 felony cases in Gilpin County last year, and we have several hundred misdemeanor cases. And so it's not unusual on a docket day to have 4 or 5 cases set for trial with your ability to try a whopping 1. And that means you're at risk of losing the other cases. The public defender knows this, and so they frequently would tell their clients, don't plead guilty to anything, even if there's a reasonable offer, because there's a good chance that your case might end up getting dismissed on the day of trial if they can't provide adequate resources. We try to deal with this by getting visiting judges and or having an extra judge come up from Jefferson County, but there's kind of judicial exhaustion in that regard, and it's very difficult to get that type of backup. And so to deal with that, I wrote legislation that said in a multi-county district like ours, as are most of the districts in Colorado, because we have 22 judicial districts and we have 64 counties, that it would be appropriate to try a case in any county within the judicial district. And if you were changing counties for place of trial, there'd be certain findings the court would have to make, in which case it could be tried elsewhere. In other words, if we ran into a bottleneck up in Gilpin County, we would have a safety valve so we could try some of those cases in Jeffco, where we have adequate resources, plenty of divisions and plenty of judges. And but we could find a Republican sponsor, but we could not find a Democratic sponsor, not a single one, in either the Senate or the House, because the Public Defender's Office said they did not agree, because of course they are benefiting from that gamesmanship, and so it was dead on arrival. That's just an example of one bill, and so it has been a tough time. And so a lot of what CDAC has done this year is not play offense, but play defense. And that is, things are frequently proposed, and they are far more extreme, and then we try to whittle it down to get a more moderate version of something we might not like to begin with passed. That kind of is the posture that we found ourselves in this year and probably next year. And next year, my understanding is on their agenda are some really big things, like they will come back with an attempt to repeal the death penalty. They will try to repeal felony murder, and habitual criminal will be under attack. And so that's what's going on at the legislature, and this year some major things happened, but probably some other significant things are going to happen next year. Some bill categories. These are the traditional bill categories, and Colleen and I have broken it up, and so we will go through them with you. The first one is pretrial, trial, and discovery, and that's Colleen's.
All right. So this first one here has already gone into effect earlier this year. This basically prohibits a court from imposing a monetary condition of bond for certain low-level offenses, and these are going to be traffic offenses, petty offenses, or comparable municipal offenses. There are some big exceptions to this. These are non-misdemeanor traffic offenses, which means DUI would not fall into this category. Other exceptions are traffic offenses involving bodily injury or death, eluding or avoiding interlock. This legislation does permit the issuance of a warrant with a monetary condition for a failure to appear, but if the defendant is unable to post bond before their next court appearance, then they will be released on a PR bond as of that date. This one has to do with admissibility of statements by a juvenile. Basically what this legislation does is it provides an opportunity for juveniles to challenge the admissibility of their statements made to law enforcement. And this is based on their basically responsible adult party who's present for the interrogation having an adverse interest to them. So this would come up in a circumstance where you have a parent who is probably the parent of the defendant, the juvenile defendant, and the victim as well. Basically, when this is raised, the burden shifts to the prosecution to prove by a preponderance of the evidence that the interrogating law enforcement had a reasonable belief, basically, that the responsible adult did not have that adverse interest to the juvenile. This legislation also redefines what protective counseling is that the responsible adult party has to offer the juvenile during interrogation, and also redefines who the responsible adult party is as well. So for the protective counseling piece of it, this is now defined as just an ongoing opportunity before and during interrogation to give the juvenile advice and counseling related to what's going on. It is only defined as an ongoing opportunity.
So this kind of continues in the vein of some of the things we saw last year. If you remember last year, the legislature changed the definition of competence as it relates to juveniles, made it a more stringent standard. So this is another piece of legislation in that area related to advisement of rights. I should tell you that, so there are probably a couple of red flag situations you should watch out for. Obviously, if you have a case where the juvenile, their parent is the responsible party, and the other victim is the sibling, so that the parent is the parent for both of them, well, that's obviously a situation where there could be a conflict that you should be aware of. It might need to go to some extra links to make sure it's dealt with. Other situation might be where the parent is the victim, or the responsible party is the victim of some act. So the juvenile broke into the house or stole something of the parents or used the credit card. Well, there, since they're the victim, they could have an interest which is adverse to that of the juvenile. So watch for those types of situations.
Well, and so what should we do in that sort of situation?
That kind of comes into the piece of where the responsible adult party definition has changed, because that definition has expanded and it's beyond maybe just a parent or guardian of the child now. So it can be a parent, guardian, legal or physical custodian of the child, or other responsible adult who was a prior custodian of the juvenile, or a responsible adult who has assumed the role of the parent for the purposes of the interrogation. So you may see this in circumstances where maybe it's an older adult sibling or something, or another family relative, something along those lines, who's just assuming that guardianship just for the interrogation.
It seems to me like the adverse interest seems like it's pretty broad, so can the defense start really just nitpicking anything in there that comes out?
I think a key part of this is going to be that the person doing the interrogation actually has to have a reasonable belief that there is no adverse interest. So you're looking at something that's going to be obvious in the circumstances of the arrest of the juvenile or detention of the juvenile and the interrogation itself.
Yeah. So that's why I mentioned those red flag areas or areas where it's going to be hard for you to say that it was obvious that there was not an adverse interest, and so something that you might need to cover. Right.
So I apologize, I'm late. Forgive me if you guys have already touched on this. If they go down with the juvenile because the juvenile's being interrogated because of a fight at school or something like that, and the juvenile says, "Yeah, I punched that kid in the nose, but it's because my dad is sexually abusing me," this would render those statements inadmissible. The guy in the lobby is sexually abusing me. What do? We just shut down our advice to law enforcement is to shut that statement down?
Your advice would probably be to, if you think that there is a problem, that you need to look elsewhere for protective counseling. So if you identify that there's an adverse interest, you say, hey, is there someone else that could advise your son or daughter about whether they should waive their rights and talk to police officers? Yes, it's cumbersome, it may be impractical, and yes, Matt, in many circumstances, it may shut down the questioning or put at risk suppression. That's probably what was intended by this, but that is the reality.
Thank you.
This next one is going into effect partially August 2nd of this year, partially into effect July 1st of next year. And this is basically just kind of an opt-in program for anyone involved in the court system, mainly for defendants, to opt into a reminder program where they'll get text message reminders of court appearances, hearing things of that nature. And there's also a data collection piece to this too. This is basically intended to reduce the number of failure to appears in court. So with this program, they're going to be collecting the data, seeing if it is effective in reducing failure to appear. The contact information that is used to opt into this program is not usable for any other law enforcement purposes, and that's to encourage participation in the program. If someone misses a court appearance, they also do get a text message reminder that they have missed a court appearance and they need to contact their attorney in the court. This one here has already gone into effect, and what this did was amend the statute of limitations for the mandatory, basically a failure to report under the for a mandatory reporter for child sexual abuse. And this extended the statute of limitations on a failure to report from a period of 18 months to 3 years. And it does apply when they have reasonable cause to know or suspect that the child has been subjected to unlawful sexual behavior or has observed the child subjected to circumstances or situations that would reasonably result in unlawful sexual behavior. This piece of legislation amended the child hearsay statute, and this affects the admissibility of out-of-court statements made by a child For children under the age of 13, their statements are admissible in any criminal, delinquency, or civil proceeding where they're the victim. So children under 13 where they're the victim. Then also the piece, they amended the piece that applies to descriptions of unlawful sexual behavior. Unless there's the charge statute defines child, then the applicable age is under the age of 15. This would apply to children under the age of 15 when they make a description of all or part of an offense of unlawful sexual behavior. And again, this applies in any criminal, delinquency, or civil proceeding. You do have to follow the same statutory requirements as part of this. There's always a hearing on the reliability of the statements that occurs pre-trial. This one here, the crossed out portion at the top of the slide, was actually amended out of the legislation very shortly before its passage. This bill was intended to have bond setting hearings within 48 hours after a defendant arrived at a jail or holding facility. That did not get enacted into law this year, but what did is that the chief judge in every judicial district is required to meet with stakeholders, meaning DA's office, public defenders, sheriff, and the commissioners, to create a plan in every judicial district for holding bond hearings within 48 hours of arrest. And also a piece of this that goes into effect January 1st of this next year is that a defendant must be allowed to post bond within 2 hours of the receipt of the bond information. And there's now limitations on the amount of fees that can be charged as part of that. They can be charged a credit card fee, no more than a $10 bond processing fee now. And then after they have posted bond, they must be released within 4 hours. The exception to this is if they need to be fitted with electronic monitoring device as a condition of bond, in which case they cannot be held longer than 24 hours unless there is a named protected party that the electronic monitoring is required for, in which case then they actually have to appear before the judge again and explain the reason for the delay beyond 24 hours. But it can be extended.
So this is an example of one that would have been worse, but because the intention of the bill was to require a bond setting within 48 hours. Now note, it's not 48 hours of when the charges are filed against them, it's 48 hours from arrest. And so sometimes it can be several hours between the time that they're actually booked in and from the time that they were arrested, as we know. If they went to a holding cell elsewhere and were being processed or interviewed, those types of things. The real objections came from the rural communities that don't have weekend advisements, aren't set up that way, may not have a judge available like that, and so their objections are probably what caused them to take it out, so that they say that we have to try to implement those types of procedures. Here in Jeffco, we do have weekend advisements. We have advisements on Saturdays or on Sundays if it's a 3-day weekend, and generally they start at 1 o'clock, and so we're trying to figure out how to comply with this. Do we have to also do weekend advisements on Sundays? Can we do we have to push it back to maybe 5 o'clock for Saturday advisements, so that one of our deputy DAs has to give up their dinner with their family in order to advise? We don't know. We're working it through, but that's what's going on.
And this next one was a very big piece of legislation. It's about 60 to 70 pages long. Parts of it came into effect as of July 1st of this year. Pieces of it won't come into effect until July 1st of next year. But basically every section of the competency statutes changed. This legislation was triggered by, there was a lawsuit, the state hospital was sued in federal court. They entered into a stipulation about deadlines to provide beds for restoration services, things of that nature. They failed to comply with the stipulation. There was a second settlement. And this legislation basically took those deadlines and timelines that were part of the settlement and made it into statutory provisions. So there are all kinds of deadlines for the initiation of evaluations, transporting defendants to the hospital, guidelines for in custody versus out of custody evaluation and treatment if restoration services are needed, guidelines for inpatient restoration, and it also defines, creates 2 tiers of defendants who are in need of restoration services for competency. Tier 1 is basically very high risk, high need type of defendants, and they will be required to have inpatient beds available for them now within 7 days of having restoration services ordered by the court. And then everyone else falls into that kind of tier 2 category where they have more time and also the ability to kind of extend that timeline based on need. This one big thing that this legislation does is it permits civil commitment proceedings to begin while a criminal case is underway as well. One piece is that when a competency evaluation is ordered, there's provision in the statute for court assignment of a court liaison, who basically is a kind of a go-between between the court, the defendant, and the state hospital, to basically provide communication, ensure deadlines are being met with, find out kind of status of delays, things like that. The First Judicial District has a pilot program going on with this called the Bridges Program that will be basically assigning these court liaisons. They'll have an initial consultation with the participant, and then they'll have specific reporting obligations to the court.
So we have 2 divisions, Division 3 and Division 12, which are our pilot district court divisions, and 1 county court division to try to help see if the liaisons can't streamline this process and move people through quicker.
The dismissal provisions were also amended as part of this. If a defendant is civilly committed during the pendency of the criminal case, the court can dismiss the case. If there's no substantial probability of restoration in the foreseeable future, that's basically the constitutional standard, the court would dismiss the criminal proceeding. For anyone who's receiving in-custody inpatient restoration services, for any crime, it would be basically the single most serious charge, the max sentence, less 50%. Once that in-custody time has been reached, the court would dismiss the charge. For non-VRA misdemeanors, it would be 6 months of receiving in-custody competency restoration. And then for non-VRA, F5, F6, drug felony 3s and 4s, and then VRA misdemeanors, it would be 1 year. And then for F4s, VRA, F5, and F6, this does exclude any violent crimes and sex offenses. It would be dismissal after 2 years. The district attorney does have provision to object to those, but the burden's very high on the prosecution to object to dismissal under those circumstances. We would basically have to establish by clear and convincing evidence that there's a high need for the prosecution and that there is a reasonably foreseeable, a substantial probability of restoration in the foreseeable future. And then the court, if they're going to dismiss a criminal case under any of these for any of these time periods here, they can stay this dismissal if appropriate to initiate civil commitment as well.
Okay, let's talk about what was done in terms of any new crimes or how sentencing provisions may have been affected. And here they created two new crimes. And camping in designated area without a permit is a crime. I believe that's a petty offense. And then stand-up paddleboard without a personal flotation device, okay? And then they also changed the way in which wildlife fines are allocated. That is, who gets the money from the ticket? Is it the Division of Wildlife, or is it the municipality? Something that probably doesn't affect any of us very much, except I suppose we may have people camping in designated areas without a permit as part of the homeless population. So maybe we'll see some tickets in that regard. Another really serious crime, and it requires now that if you operate a freight train, that you have a minimum of 2 crew members. If you don't, you're going to be subject to these fines. And ironically, if you operate a passenger train carrying people, you only need one person. But it's only if you have a freight train, you need 2 people on board. I don't know if there was some real problem with them not having enough people on freight trains, or if the unions wanted to increase the number of employees on freight trains. But that's now the law. And this is Punky's Law, it's called. It's an animal ban for cruelty to animals conviction. And so, who is Punky? Now you might think, well, Punky must to be the inspiration for this law. He must have been horribly abused or something very bad, right? Well, no. The legislator who proposed this legislation, well, his prize pet was Punky, and Punky happened to die during the legislative session, so the legislature named the law after his dog, okay? That's how things are done down there. And, but in any event, I kid you not, okay? But it requires a court order prohibiting a person convicted of felony animal cruelty from owning, possessing, or caring for a pet for 3 to 5 years, unless a treatment provider makes a contrary recommendation to which the court agrees. And so to that extent, what it says that they can't have other animals to abuse if the court makes that order. Now, if the person's on probation, well, I suppose that could be made a condition of probation. If they're not, I'm not sure how it's enforceable. That is, if they're on probation for 1 or 2 years, and this is for 3 to 5 years. But that's what has been ordered. In the juvenile area, it can be any conviction for cruelty to animals, and so it could be a misdemeanor conviction also. It also requires a comprehensive evaluation to determine causative factors. If a felony demonstrating knowing torture or torment, and then allows the court to order an offender to complete mental health treatment designed to address underlying causative factors. And so this is an effort to get some enhanced protection to animals that might be the subject of abuse, and keep those types of animals out of people who have a tendency to abuse them. You'll find out with some of the legislation that anything involving animals has a good chance of passing through the legislature, and if animals are victims. And this is a change. They've lowered for a Class 2 misdemeanor. The penalty was 1 year in jail. They lowered it to 364 days. And I see some of you shaking your heads. The reason they did that is because they realized that immigration, ICE, frequently looks at when someone pleads guilty or is convicted of an offense, can they get a year or more in jail? If they can, it could be subject to deportation. And so for that reason, they lowered the penalty for a Class 2 misdemeanor, for all Class 2 misdemeanors, by 1 day, so that the conviction of that could not subject anyone to removal from the United States. And so that's what that's about. Here, something involving animals, and last year they created a new law, which was under cruelty to animals if you abused a certified police working horse. There's only one problem. That is, the geniuses at the legislature didn't realize that there's no such thing as a certified police working horse. There are police working horses, but there's no certification program, and so they created a law last year which absolutely had no effect. And so when someone brought this to their attention, they thought that they would improve it by simply making it relate to working horses now. Yes?
Does anybody ever keep track of the time that was wasted on something this stupid and track it before someone comes in and says that this really won't work, this horses aren't certified?
I'm absolutely certain no one does anything like that. Okay?
Or ever will.
Yes. And
Pretty
when you're in the
sad.
legislature, you get to have 5 bills a year that you can pass. And so for some people that's not a quota. That means it doesn't mean that you should do 5 bills, have to do 5 bills a year. But many of the legislators consider it that way. So if they don't get their five bills in, they don't think that they can go back to their constituents and say, hey, I've been doing my job passing legislation. And so there are some pressures for them to pass things, even if they don't mean anything. And this is something that's going to have a big impact on us, probably of all the legislation that was passed. The competency statute that Colleen just talked about is going to have a big impact, not so much on you, but on the district attorneys and the system. But this is going to have major impact on law enforcement and on charging decisions. And so, right now, if you possess heroin or methamphetamine or any Schedule I or II controlled substance, amphetamine, cocaine, it is LSD, it is a DF4. And this is now changing all possessions to a drug misdemeanor 1, unless there are more than 4 grams of controlled substance, or unless a person has at least 3 prior convictions, and so this is their 4th offense for that, it can remain a DF4. And so this is going to be have a big impact on charging decisions. Let me put it in perspective here in Jefferson County. Last year we filed a little over 5,000 felony cases. Of those, 1,800 of our cases had a drug felony 4 charge associated with felony cases. About 600 of those were DF4s coupled with some other felony offense, or coupled with a higher drug offense. And so there were about 1,200 DF4s which were coupled with a misdemeanor or standing alone. And so about 1,200 felony offenses are now going to be swept probably into county court, as opposed to maybe a little less than that number, but of that 600 felonies I told you before, about 100 of those were a violation of bail bond conditions with the other felony associated with it, because they were, of course, on supervision for that felony at the time they committed another felony. We won't be able to charge those anymore. So by my estimation, we're probably looking at about 1,200 of our drug possession felonies will now become drug misdemeanor felonies. And so that's going to have a big impact, especially on our county court. There might be some temporary relief for our intake unit and for our district court. I say temporary because right now, at least with the structure we have some incentive for people to get drug treatment. And because they can try to avoid a felony conviction, they can wobble down if they don't have too many prior convictions. Much of the incentive through the legal system to get treatment has been dramatically reduced. And so this law is only only have one effect when it comes to drug use and drug addiction, to make it increase. I mean, there's no possibility that it could go the other way. And so we are probably going to see more people in the system, and some of those extra people will be committing other felonies because they will be stealing cars and breaking into houses and breaking into cars and shoplifting and doing all those things that we know are associated with drug offense.
Next
So,
question.
yeah, go ahead, you first, Lee.
So your bullet point down toward the end, arrest no longer permitted for possessing less than 2 ounces.
That's
What
marijuana.
drug are we talking about?
Marijuana,
Of marijuana.
yes.
So, I'm just looking at some of those drugs up there. I had a case at Bear Creek with, I don't know, let's say 5 tabs of LSD bladder acid. That would not be included in this because it's not one of those.
No, LSD is,
It's
is a class 1, Schedule 1 controlled substance.
It's a
So-
Schedule 1, but I saw any quantity, I didn't think LSD fell under any of those names.
Yeah, so it doesn't, it's not mentioning these specific things which are mentioned in the statute, but it's a Schedule 1 or true controlled substance. So it falls under that. So yes, your LSD will now be a misdemeanor, okay? And maybe in Denver, maybe not even that. Oh, right. So right, so yes, this is going to have a big impact in that regard. Now they have changed slightly the penalties associated with the DM1, probation up to 2 years, and up to 180 days in jail. If it's a third or subsequent, they can get up to 364 days in jail, not a year, 364 days in jail. And so there is some possible consequence. This is actually an improvement because the way the bill was originally written, they wanted all possession, regardless of the amount, to be the DM1. And so pressure from law enforcement and CDAC at least got it changed to 4 grams. And they wanted no jail possible for a DM1, so that there would be no incentive in order for people to get treatment. That is no fear of consequence. And so at least that didn't happen. And then a drug misdemeanor 2 is up to 1 year probation, up to 120 days in jail, third or subsequent 180 days in jail. And so there are many of us in the law enforcement community that already feel that Colorado has gotten the reputation as being a destination state for drug tourism, especially marijuana. And this now kind of continues to move us in that vein with respect to drug tourism by dramatically lowering the penalties associated with possession of some very serious controlled substances. And penalties for failure to pay wages. They create a crime of wage theft, and so it increases the offense from a misdemeanor to a felony when wages are not paid to an individual that are owed. And it's a felony if it exceeds $2,000, and then it adds coercion to the list of qualifying intents for the crime. This might happen in a couple contexts. Obviously, if you have people that are undocumented aliens and they're working, sometimes they're exploited. That is, people will say, I'm not going to pay you the full wage I owe you because if you complain, then it will be brought to the attention of the authorities that you're not legally in the country and you may be deported, right? And so this is aimed at that type of situation. It also deals with this provision in there to deal with minimum wage. If they are supposed to be paying the minimum wage, but they're paying less than the minimum wage, when it hits $2,000 of underpayment, it could be wage theft. Ban posting images of suicide. This comes about as a result of the tragic situation where a 13-year-old, Havan Mercado, committed suicide. That was video recorded, and then it was shared on social media in an effort to pressure his friends to also attempt to commit suicide. Prior to this bill, it wasn't a crime to report a suicide or post it online or try to persuade others to commit suicide. So this creates a class M3, misdemeanor 3, if someone intentionally posts or distributes an image of a minor attempting suicide, dying by suicide, or having died by suicide with the intent to harass, intimidate, or coerce any person, and the distribution results in serious emotional distress to any person. Seems like a lot of elements for a class that would have to be proven for a class 3 misdemeanor, as opposed to just saying it's a class 3 misdemeanor to do this. But and that's only for the first person to distribute it. If the second person distribute it, well, then it creates a civil infraction with a $100 penalty for all others. Now, I don't know what a civil infraction is. Matt, do you know what a civil infraction is?
Speeding.
Okay, and so I'm not sure exactly how that will be enforced. But the intent is probably good, but obviously what they've created is pretty watered down in terms of having any big impact on anyone or any substantial consequence for anyone for doing this. Organized retail theft prevention. Now, this probably makes some sense. And remember, we probably should change this slide. So it is in class 3. Yeah, we have changed. Okay. And we have a situation with respect to shoplifters that if you go into Home Depot and you buy a lawn and you steal a lawnmower, and then you take it in to return it, they're not going to refuse to take it back if you don't have a receipt. But if you have a receipt, they'll just recredit it on your credit, debit it on the credit card, give you the money back. If you don't, they will give you a refund for it, but they'll give you gift cards. And so we have a lot of people that are engaged in shoplifting activities, stealing places, things from places where they are given a gift card. And so what these people want to do, of course, is they want to actually have money that they can buy drugs with. And some of their drug suppliers might not actually take gift cards for the drugs. And so they resell them to secondhand places or to places that run flea markets or sell secondhand goods. And so in recognition of that, they've actually created a registry. And so people that actually buy gift cards from others are supposed to keep the documentation for a certain period of time. And then they're also supposed to put this into an online registry that law enforcement, that you folks can access so that you can see if there's a lot of this going on that would give you a feel that some person might be a habitual shoplifter or involved in that business. So to that extent, that's good. These penalties are for people who don't comply with the registry requirements or keeping documentation. It creates these level offenses. And remedying improper guilty pleas. It was recognized that, well, back to immigration again, that we would sometimes give people deferred judgments and sentences. And so if they completed the case, their conviction then does not enter. It was deferred, the case is dismissed. However, immigration authorities would not necessarily consider it dismissed for purposes of removal or consequences associated with immigration. And so even though the case was dismissed in state court, they might still consider that in deciding whether or not someone had committed a crime of moral turpitude and should be deported from the United States. And so to that extent, they passed legislation that say that if a person is in that situation, their whole proceeding can be vacated if they weren't advised that immigration could consider their dismissal still for the purpose of immigration consequences or removal from the United States. And so that's what this law is about. And so to that extent, we have plea agreements, when people enter pleas, we have modified those to add language like this to the plea agreements if they're getting a deferred judgment and sentence, so they're properly advised. And we're adding now to all our plea agreements a line where the attorney has to sign off that they have discussed with the defendant immigration consequences, including this, so that we can address it. But that's what this law deals with. We won't deal with anything that you guys deal with out on the street. And protection from unlawful abandonment and confinement. It makes it a class 1 misdemeanor to abandon an at-risk person. The unlawful abandonment is the intentional and unreasonable desertion of an at-risk person in a manner that endangers the safety of that person. The background on this, there was a person in Florida who I believe was being taken care of by his son, and other family members that weren't helping out. And he got tired of this, and so he put Grandpa on an airplane, sent him to Denver, called the other family members up and said, hey, Grandpa's on his way to DIA. I'm done taking care of him. Tag, you're it. It's your turn to take care of Grandpa. And apparently, Grandpa got off the plane, and these people didn't want to take care of Grandpa, and so he was wandering around there at the airport. It's actually obviously a bad situation. And so to deal with that type of thing that apparently does happen, as this one example shows you, they created this class 1 misdemeanor to abandon an at-risk adult. It's probably a good thing to do. And then they also created crimes of false imprisonment of at-risk persons, knowingly and unreasonably confining or detaining in a locked or barricaded room, and such confinement is part of a continued pattern of cruel punishment or unreasonable isolation or confinement. Would be a class 6 felony. Knowingly and unreasonably confines or detains by tying, caging, chaining, or similar, it would be a class 6 felony. And then knowingly and unreasonably confines or detains by means of force, threats, or intimidation would be a class 1 misdemeanor. And so these are probably some additional tools we can use in situations involving elder abuse or at-risk adults. Note that it doesn't require any injury to the people. There's an affirmative defense built in with respect to care establishments that have the obligation, of course, to maybe care for people with memory disorders or something else, and therefore they might be locked facilities so that they're not automatically swept in this. Pat, are you seeing many cases that would fall into this type of situation?
We certainly have.
Yeah.
And it's usually, I know that affirmative defense, we get calls periodically of an at-risk person that the family they won't, if they get out of the room or the house, they're going to take off. They're going to wander. And so they want to lock the door.
Mm-hmm.
And they will occasionally call or have concerns about that, knowing what this is now.
Right. And so note that it has to be in a manner that endangers the safety of that person. So here they're locking the person up in a manner to actually protect that person. At least, and so that scenario may not fit.
Right.
But some other scenarios might. So an extra tool in your box in case you need it. And so that's probably not a bad thing. And community corrections and parole. Currently, at the Department of Corrections, if the vacancy rate hits 2% of the total capacity, that then kicks into place certain procedures by which the director of the prisons has to give a list of names to the parole board of people that might be eligible for parole release, kind of as a safety valve. And so it's at 2% now. They've increased it to 3% of the total population in the prison. I should tell you that here in Colorado, since 2010, we have had a 16% increase in population, and our prison population has actually gone down by 10%. But they've been closing some prison facilities, which keeps things closer to this vacancy line. And but that's the reality in terms of the numbers in the Department of Corrections. Another thing that they did was, and this continues a trend with respect to watering down parole supervision. So last year, one of the bills that was passed actually reduced the length of parole supervision for a number of felony offenses. There's been a practice that was instituted by the Department of Corrections to try to minimize the number of people that are sent back to prison as a result of parole violations, and that is to ignore technical violations. What's a technical violation? Well, a technical violation is essentially anything that is not a new violation of criminal law, is what is a technical violation. So this codifies some things that they indicate that if there are technical violations, that parole officers are given the ability to sanction parolees by sending them to jail for up to 14 days as an intermediary consequence. It also limits the return to prison based on technical violations to those who have possession of a deadly weapon, or in a sex offender treatment program and are not complying, abscond, or willful failure to comply with a summons. And so if they've been given a summons and for a new criminal offense but don't show up, and or tampering or removal of a GPS. Otherwise, the parole board can order treatment and not send them back. And so there is a real effort not to send people back for technical violations. The biggest technical violation is probably drug use and substance abuse, curfew violations, association with other known criminals or felons. Those things, they will not send them back to the Department of Corrections anymore. And then it provides that persons discharged from DLC without a supervision plan are eligible to receive re-entry support services for up to 1 year. That's probably a good thing, because sometimes we have people being discharged from the Department of Corrections. They've killed their number. They didn't want parole, and so they're just being released. And they don't have any re-entry services. So this makes them eligible for some limited re-entry services for up to a year, hopefully to give them a better chance to transition and maybe cut down on the recidivism rate, which of course is very high.
All right, these next ones are mine. Some ones that are directly applicable to peace officers and relating to the post board. This first one is an information sharing grant program. What this does is basically allow different local law enforcement agencies to apply for grants, which allow them access to the Colorado Information Sharing Consortium. So basically, information sharing between different law enforcement agencies and just to provide more complete information for policing activities. Applicants will be considered for grants out of this program based on financial need, commitment to sharing data between agencies, and then also there'll be security regulations for data sharing to keep it within basically the federal data security requirements. All right, this next one, what this does is it makes an internal investigation file of a peace officer subject to open records requests. And this applies to completed internal investigations for peace officer conduct involving a member of the public while in uniform or on duty. And this will only apply to completed investigations, and that includes all appeals processes. Basically how this process is going to work is The custodian of records will receive a request for the internal investigation file if there are no ongoing criminal cases, or if the investigation is all 100% completed. They can provide a summary to the requester if the summary is sufficient. If they are requesting further information, they make that request. The custodian of records then, under the statute, has a list of required redactions that would have to be made to that file. Personal identifying information, things of that nature, personal addresses, things like that. And then there are also discretionary redactions that can be done as well, and that would be confidential witness information, things of that nature. And then, like I said, if there is an ongoing criminal case at the same time, access to the file can be denied. And at any time, if they feel like they're being wrongfully denied access to a file, or if information is being redacted improperly, the person requesting can basically request that the district court issue an order to show cause as to why the whole file shouldn't be released. And then the district court will review it and can order release of the information. All right, actually, I should note on this one did come into effect April 12th of this year. And this only applies to investigations that were started as of that April 12th date. So it's completed investigations that were started April 12th or after. This one is legislation that expands the Peace Officer Mental Health Support Service Program, and it includes access to additional types of law enforcement agencies. So basically, Parks and Wildlife, Colorado Bureau of Investigation, things like that. It's intended to provide services to promote mental health. This one is basically a piece of legislation that's a 3-year data collection. It places burdens on county jails as far as record keeping. Basically, they're going to keep daily records of inmate numbers, demographic information, length of stay, case status, and then this information would be available to the general public. They'll also be providing quarterly reports to the Division of Criminal Justice as well. This piece of legislation is to basically encourage all law enforcement agencies to develop policies and procedures for use of force situations. So all law enforcement agencies will be required to implement new policies for pre-incident training, preparation, support to peace officers when a use of force incident happens, and then basically a timeline and guidelines for any sort of support after the incident, return to duty, things of that nature. These policies would then need to be implemented as of January 1st of this next year, and then on a biannual basis, law enforcement agencies just need to review and update those policies.
Is support defined?
I'm sorry?
Is support defined?
Defined. It is not directly defined, but where we have, say, just it briefly on the slide right here, in the actual legislation itself, that's quite expanded. So there are a number of different examples that are given within the legislation for types of support services, whether it be peer support, therapy, mental health services. There's a variety of different things listed. This next piece of legislation will come into effect August 2nd of this year. What this does is it will require the post board to revoke certification for peace officers who have knowingly made a false statement or omission of material fact on an official criminal justice record while testifying under oath or during an internal investigation or administrative process. So basically, basically how this would come about is the agency employing the peace officer would do an investigation, and then that would include basically a full, whatever policies they have for investigation appeals process within the agency itself. And if they have then made that determination, then they would have to certify to the post board by clear and convincing evidence that they have reached this determination that there was a false statement or an omission of material fact. And then the post board would then inform the peace officer, who could request a hearing through the post board. They would hold a hearing on it at that point. If they then determined that this in fact happened, the law enforcement agency met their burden by clear and convincing evidence, then they would have appeal rights through the post board, and then could also petition for judicial review under Colorado's Administrative Procedure Act. All right, these next ones are yours.
And with respect to victims and witnesses, one slide that is not up there, but one good thing that was actually done was that in the past, if a person was convicted and was sent to the Department of Corrections, for instance, if they wanted to be notified when a defendant was released, or if he was going before the parole board, they had to opt in. They had to actually fill out a form that was then sent to them to say, I'd like to be notified. Now victims automatically are opted in, and so it's not necessary for them to fill out a form like that. So that's a positive change that was made, and we don't have a slide on that. But once again, I told you anything involving animals, there's a good chance of making it through the legislature. They've approved the potential use of court facility dogs. So it allows a witness to testify with a court facility dog if the court finds by preponderance of the evidence that the dog's presence would reduce the witness's anxiety and enhance the court's ability to receive full and accurate testimony. And then the arrangements for the dog are in a way such that the dog does not interfere with the efficient criminal administration of criminal proceedings, and no prejudice would result. I'm not sure how often we'll see this. Maybe sometimes in cases involving child victims, if they had a court facility dog and the dog might make it easier for them to testify, they will use that.
I would a golden retriever every time I testify.
Yeah, right.
So is
Yeah.
this at the courthouse, or they bring their dog in?
Well, it says it's a court facility dog, and I don't know that they are sort of like certified police animal or horse. I don't know that they are actually defined what a facility dog is, but I would imagine that it wouldn't be their service dog, because
Oh, here, it does define it. It says, defines court facility dog and requires the dog to have graduated from training
Yeah.
provided by an accredited assistance dog organization.
So they're
So
specifically
it's at the
trained for
courthouse.
that.
yes, right. So it would be a dog that was specifically
Yes.
directed at that. So probably not their service dog.
No, it's a specific training that they're
Right.
required to go through. Are the judges support of this, or have we found in Jefferson County that there is a perceived bias?
I really don't. I really don't know. I mean, I don't. I would be surprised if there's a bias. I don't think we have a program, and so if someone actually did this and set up a program where they actually had a dog, we had a therapy dog here at our office for a number of years.
Gator's
Yeah.
dog?
And yes, Mary Gabler's dog, Raven. And sometimes that would assist with interviews and meets and greets with kids and some other people. And so maybe this will do the same, be something that will be available if it was actually done by the courts. The question would be, what organization would train it and support it to make it available? Is that what the sheriff would do?
So there's a program, and there are dogs that are available.
So,
But the interesting point of this is, in Denver at least, when they had or in the box with the victim. The jury was actually polled afterwards to see if they noticed, and not one of the jury understood or knew that there was a dog, even in the courtroom. So
Right.
it's actually, they're trained specifically to be very, very quiet throughout that.
I know at DIA, they have all these comfort dogs going around with handlers now. I know that it makes Russ Boatwright much more at ease when he gets to pet one of those. Yeah.
So this would not apply for defendants that have anxiety? They can't, I see witnesses, so if a defendant says, I have anxiety without my court facility dog here, is that provided?
You know, to keep with the animal theme, you know, what's a sauce for the goose is probably sauce for the gander too. So if the defendant's a witness, I'm sure they could make that type of claim. I wouldn't be surprised, okay? Maybe that would come under the standard public defender motions. Right. And so anyways, that was passed this year. And then they have also agreed that to lower the interest rate from 12% on restitution to 8%. So now, once you have a restitution order in place, interest accrues at 12% a year. That's a lot of money, but try to encourage them to actually pay it in an expeditious fashion. So they lowered that to 8%. And then motor vehicles and traffic.
All right, now we get into some fun stuff. Like, very important winter conditions and traction control requirements.
Can I just ask a
So-
quick question?
Yes.
Sure.
Backing up just a second on House Bill 1064, with regards to the notification for victims on cold cases, have they defined or specifically put a parameter around when that starts? Is it from the end of when they just transfer the case into something that's more pending, i.e. still open but not enough evidence? Is it from that moment, or is it from the moment that, does that year start? From the moment that the case was open?
I don't know if that has been clearly defined out, right? Where do they define the starting point for the year?
Okay.
Right.
And is there a requirement of documentation on that, I would anticipate?
It requires notification, but in terms of documentation to whom?
If a buyer complaint was filed, then the city would have to have some documentation that it was acted on.
Right, and so I would think that that if people are trying to be in compliance, you're right, that they would make a paper trail with respect to that.
Okay.
We certainly try to do that and note it, for instance. And those cases usually aren't in action yet, and so you can't you can't put it into our case management system. And so I'm not sure how the victim witness will work through that.
All right. So this one will come into effect on August 2nd, so that'll be applicable next winter. Basically, on I-70 between Dotsero and Morrison, you are going to be required to have chain alternatives, four-wheel drive with tires that have a tread depth of at least 3/16 of an inch, or all-weather tires or imprinted with winter snowflake. Those also have to have tread depth of at least 3/16 of an inch. And this will be between September 1st and May 31st when icy or snowpack. I think they just decided there were too many accidents in the winter, backing up I-70 basically. And they've also decided to expand electric scooters from toy vehicle to a vehicle. You can now get a DUI on an electric scooter. So this will be more applicable to downtown areas. There's not too many electric scooters out in Jeffco and Gilpin. But for those using electric scooters, usually it is to avoid getting a DUI, but now it is a vehicle. They basically have same rights and duties as riders of e-bikes, so electric bikes, and local governments can't regulate them more restrictively, basically. This one has to do with basically the malfunctioning traffic signal statute. It added extra language into that statute to cover a circumstance where a motorcycle pulls up to an intersection, and a lot of times if it is on the weight control, it won't trigger the intersection to change. So when that happens to a motorcyclist, they're allowed to pull up to the intersection, wait until it's clear, and then proceed. This is a new class 1 traffic misdemeanor, and this is basically careless driving that causes serious bodily injury to a new class called vulnerable road users. So a vulnerable road user is basically anyone who is lawfully present on the roadway. You're looking at construction workers, utility workers, peace officers who have someone pulled over, bicyclists, pedestrians, anyone who's lawfully following the rules of the road and has the right to be on the road. Skateboarders, scooters, things of that nature. What it does is it creates a 12-point violation, allows the Department of Revenue to revoke the license, and the full list of who vulnerable road users are is, I believe it's actually all listed out in the book. It is. Right, there was also some new legislation applying specifically to juveniles. One of these was had to do with record expungement. This one basically provides for pretty much automatic expungement in cases involving diversion, deferred adjudication, or informal adjustments. The juvenile wouldn't be required to file a separate petition or case to have these records expunged. And then the district attorney's office, basically, we would be responsible for notifying relevant records custodians, schools, service providers, things of that nature, the completion of the case, that the records are to be expunged once the diversion is completed. This legislation also allows the court at the time of sentencing to address the applicability, or basically whether or not they'll be eligible for expungement at the conclusion. And then at the time that expungement is considered, the court can also address sex offender deregistration for applicable cases. This one here is basically just the formation of a committee that's going to be looking at a lot of the screening tools that are used within juvenile services and kind of remodeling and revamping those. So they're going to be looking at risk and needs assessments, mental health screening tools, plans for measuring the effectiveness of what we have in place already versus the proposed ideas, screening tools for diversion, and then this also asks the Division of Youth Services to adopt detention screening process and plan for training on that. And then there's some requirements put on the state court administrator for basically responses and incentives for changing juveniles' behavior within the court system. And then the screening tools that basically come out of this reform committee, the district attorney's office will then be required to start using not this next January, but the following year in January. All right.
Okay.
Yeah.
Marijuana, and let's talk about some of the marvelous things that they've done in this regard this year. And so one of them is in keeping with this theme of making Colorado a drug use destination, they have approved mobile bring your own pot vehicles. And so these would be hospitality, party wagons. And so you could land a DIA, you could get onto your party wagon, and the driver doesn't get to smoke pot, but all the other people inside can use pot. The driver will drive you to a pot shop and you buy pot, and then you can see beautiful Colorado from the vantage point of the hospitality wagon while you're smoking marijuana. So that's been approved, and then also retail places that sell pot, well, they'll be able to designate a portion of the area that you could actually smoke the marijuana in case you don't want to wait until you get home to smoke your marijuana. You can do it right then and there on the premises, and so that has also been approved, and makes smoking marijuana in the hospitality spaces an exception to Colorado's Clean Air Act. And so you know that generally, unless you're at a cigar bar or something that meets those regulations, you're not allowed to smoke in public places which expose other people to secondhand smoke because of the health risk. This makes marijuana an exception to that, though. And however, it does require local government approval. So it's a foregone conclusion probably that Boulder and Denver will pass this, but maybe some of the other communities won't. I don't know what they'll do, whether they'll put their pipes down when driving in between these safe zones or not, but I'm sure they will figure it out. I'm sorry about my sarcasm, but I just think that this continues the trend that we've seen with respect to the lowering of drug penalties, and that this is not good for public safety here in Colorado, but it is the law, or will be the law as of August 2nd. And regulated marijuana delivery. It also allows stores to deliver marijuana to private residences. And so now, if because you're lethargic because you've been smoking pot all day, you don't have to get up off the couch or out of your hot tub. You can simply call for it, and they'll deliver it right to you at home. I guess at least if you're not driving while you're high, it's probably a good thing. And once again, it has to be approved by individual jurisdictions. And so either the Board of County Commissioners or the City Council can, or they can have a public referendum to force them to allow delivery. And medical marijuana delivery permitting begins on January 2nd, and retail marijuana delivery permitting begins on 2020, retail on 2021. So they're going to let people getting medical marijuana get it sooner delivered to them at home because apparently they have medical needs. And marijuana sunset. This clarifies, actually defines some of those terms like open and public consumption, what is meant by that. So that's good to probably have some guidance. It makes unlawful acts for medical and recreational marijuana consistent, and then it adds 2 new unlawful acts: engaging in regulated marijuana business without a proper license, and then altering marijuana samples to circumvent testing requirements are 2 new low-level criminal offenses. And human trafficking. And so it creates immunity for a violation of a prostitution-related offense if probable cause exists to believe that a minor was a victim of either human trafficking for involuntary servitude or sexual servitude. And so if there's an exploited minor and they've been exploited so that they've been involved in prostitution, they're immune for being charged with prostitution-type offenses. And then if a law enforcement officer encounters such a minor and there's probable cause to believe that the minor was a victim of human trafficking for sexual servitude, the officer is now a mandatory reporter and must report this to the Department of Human Services. And then it establishes an affirmative defense for all violations of criminal offenses except Class 1 felonies if a minor proves that he or she was a victim of human trafficking for involuntary servitude or sexual servitude and was forced, coerced into engaging in those criminal acts. In other words, duress right now is an affirmative defense to certain crimes, and so if they can show that they were forced to commit certain crimes lower than a Class 1 felony, and they were coerced or forced into committing those crimes, then it could be an affirmative defense that we'd have to disprove beyond a reasonable doubt, is what it does. And then some other sexual offenses, unlawful electronic sexual communication. If a person is in a position of trust, they're prohibited from inviting a person who the offender knows or has a reason to believe is between ages 15 and 18 and at least 4 years younger than the offender to expose or touch or observe that the offender's intimate parts via electronic communication. We have internet sexual exploitation right now. It deals with minors. This is tightening it up to 15 to 18 year olds if there's a position of trust. It's a Class 5 felony and a Class 6 felony and 5 if committed with the intent to meet for sexual exploitation or contact. And then it requires a person who commits unlawful electronic sexual communication to undergo sex offender treatment and to register as a sex offender. And so just adding some provisions to deal with the electronic exploitation of children by people in positions of trust. This makes some changes to the definition of sexual contact. And so sexual contact, which before might have been touching for the purpose of sexual arousal or gratification or abuse, also has now added the knowing emission or ejaculation of seminal fluid onto any body part of the victim or the clothes the victim is wearing, or knowingly causing semen, blood, urine, feces, or other bodily substances to contact any body part of the victim or their clothes if it's for the purpose of sexual arousal, gratification, or abuse. The backstory on this is actually one of the cases that is in our case law update. And so what happened was there was a person that was convicted of sex assault on a child. What they did was they ejaculated into the hand of the child without actually touching the child with their penis. And then they made the child, I believe, eat the ejaculate. And so pretty disturbing and aberrant behavior. The Court of Appeals reversed the conviction for sex assault on a child, saying, well, the definition of sexual contact actually doesn't fit this scenario because the person's penis did not come into contact with a part of the victim. And so the legislature said, well, that doesn't make much sense. And so we're going to tighten this up to make sure that this type of situation, hopefully this type of aberrant situation, but this type of situation can be dealt with through a criminal prosecution in the future. So that's an example of them being responsive to something that the courts have done. And sexual assault while in custody or detained. So this has to do with police officers. It prohibits a peace officer from knowingly engaging in sexual contact, which would be an F4, so that is touching or doing one of the things that we just talked about, and intrusion or penetration, an F3, when in the same encounter, the officer contacts the victim for the purpose of law enforcement or exercise of an officer's employment activities. The officer knows or causes the victim to believe he or she is subject to an active investigation and uses that to further sexual contact, or in furtherance of sexual conduct, the officer makes any show of real or apparent authority. And so it's directed at peace officers who, in a law enforcement contact, try to use that in order to exploit the suspect into having sexual contact or sexual intercourse. And it doesn't apply in situations if it's part of a valid search. And consent is not a defense. And so the fact that the person consented is not a defense to this. And it's treated sort of like sexual contact on a child would be treated. Hopefully we won't see too many of these offenses. And some other crimes of interest.
All right, so this first one basically deals with Colorado law enforcement agencies and cooperation with federal immigration authorities. So this basically just prohibits law enforcement from detaining or arresting an individual based solely on a civil immigration detainer. What this does not do is it does not prevent law enforcement officers from being responsive to a warrant from a federal judge or cooperation with a writ from another state or federal authority. This does not prevent cooperation between federal authorities and local law enforcement agencies. Officers also can coordinate telephone and video interviews between people who are in custody and federal immigration authorities. But in doing so, they do need to be advised in writing that the interview is being sought by federal immigration authorities. They do have the right to remain silent and decline the interview. They have the right to speak to an attorney, and anything they say can be used against them. This next one was a very controversial piece of legislation that passed this year. It was proposed in response to the killing of Deputy Zachary Parrish in Douglas County in response to an incident with an armed mentally ill suspect when he responded to a domestic disturbance. Basically, what this legislation does is it works very similarly to a civil protection order. It allows family members, household members, or law enforcement agencies to petition the court for something called an extreme risk protection order. It begins with an ex parte hearing, just like a civil protection order does. The judge, the petitioner has to establish to the judge, and they make the finding, that by a preponderance of the evidence, the person proposes a significant risk to themselves or others by their possession or purchase of a firearm. And then they enter the order banning them from purchasing, possessing, or otherwise obtaining a firearm for 14 days. At that point, the protection order is served on the respondent. Then they come back for a hearing within 14 days. At that point, the judge then, the petitioner has the burden by clear and convincing evidence at the second hearing that there is that risk. It's the same significant risk to self or others. They'll hear from the respondent as well, and then if the judge finds by clear and convincing evidence that that protection order needs to be in place, that will be in place. Then it's called a continuing extreme risk protection order. That'll be in place for 364 days. During that period of time, the respondent, who's the subject of the order, can apply for termination once during that year period. Then the burden does shift to the respondent at that point in time to show that they are not that significant risk. And that burden is by clear and convincing evidence as well. When those 364 days are up, the petitioner can renew that protection order, and then the burden is back on them to show that there is that continuing significant risk. Failure to comply with one of these protection orders will be a Class 2 misdemeanor.
So, Colleen mentioned that this is a controversial piece of legislation. Jeff Schrader, our sheriff, has indicated that he's gotten more calls on this piece of legislation after this legislative session than he's received in the entirety of his career for 5 years with respect to all other matters combined. And so there is a lot of public concern about this. In terms of what's happened, your departments probably will work out some type of procedures in terms of how these will be executed or how these will be handled. There are 2 categories that can apply for one of these. One of them is law enforcement officers from law enforcement agency, and the other one are family members. And the sheriff has instituted certain guidelines as to how they are going to handle this and what their role is going to be. And for the most part, they're letting individual law enforcement agencies will have the primary responsibility for executing these types of things. And so I would imagine your departments are going are trying to figure out what you're going to do and to what extent you're going to do it.
With that, I will note a couple of things. When law enforcement seeks one of these, the idea is that it will be at the same time as a search warrant. So there would be an application for a search warrant at the same time, searching for the firearms. When a continuing protection order is put in, the one that's going to last that year, the respondent has basically 2 days to certify to the court that they don't have any sort of firearms in their possession. And at the end of that 2 days, if the court has not had any communication with the respondent, they inform local law enforcement, and then it's the responsibility of the local law enforcement agency to then let the court know that to the best of their knowledge, there are no firearms.
How might this affect the usual police officer scenario where you see a kid posing on social media with a gun to his head or pointing a gun at the camera? Usually it's not the kid's gun, but it's grandpa's gun or dad or mom's gun. How might that bleed over into getting some sort of order here on the kid?
Well, definitely, I don't think that there would be anything that would prevent one of these from being entered against a juvenile at all under the language of it. And in the scenario that you just posed, where it's the school
I'm going to shoot
resource
up such and such
officer,
school, and he has a gun pointed at the camera.
then, I mean, that would be the law enforcement agency petitioning for the protection order itself. And then that would be, with an asking for a search warrant at the same time, that we would have to be supported by probable cause that there's firearms. And you're also looking at this still as the petitioner, the preponderance of the evidence. So the court for the first hearing, right?
Yeah, it's interesting because we'll have often threat assessments at schools in which it becomes kind of a quasi-school police investigative matter to determine the threat level for that school because the kids was seen in possession of a gun, but then there's going to be a lot of bleed over with this.
Right, so I suppose the
For
question,
order.
right, the question would be, is that the route that you want to take, or do you want to get the parents involved as part of the process and so that they can intervene and remove guns?
Right.
So you have to make that decision. There's nothing in this that tells law enforcement that they have to do these or when they should do it. It's a tool that would be available. It would also be available to the family of the child to seek that, but that would be strange if the child was living in their own home. The DA's office is not going to be involved in these things, except if somebody is charged with a protection order violation for not complying. So they're ordered to turn over their guns, they didn't turn anything over. Well, well, then they're charged with a protection order violation, which is a class 2 misdemeanor. We might be involved in that situation. I suppose we might be involved if, as part of the search warrant, assault by law enforcement, they asked for no knock because they thought the person was armed and dangerous. Well, then we might have to sign off on one of those. But to the extent, other than that, the DA's office is not going to be directly involved.
All right, along with the competency statutes, one of the largest changes this year was basically a complete overhaul of criminal records sealing. The idea was to kind of create a simplified criminal record sealing process, almost automatic in certain cases where either no charges were filed or all charges were dismissed, situations like that. It does expand the ability to seal convictions within timeframes that are a little bit adjusted and shorter than they used to be. For petty or drug petty offenses, if from either the date of completion of the sentence or last criminal proceeding, whichever date is later, there are no subsequent criminal convictions for a period of a year, those records will be eligible for sealing. For class 2 misdemeanors, class 3 misdemeanors, drug misdemeanors, that is a period of 2 years. There are notification requirements under the new statute for the district attorney. On VRA cases, we notify the victim. If it's a VRA case, the victim can object and request a hearing. The district attorney also has the ability to object and request a hearing. The period is 3 years on F4s, F5s, F6, drug felony 3, drug felony 4, and class 1 misdemeanors. These again have the same sort of notification, objection, and hearing requirements. For any other eligible offenses, the period is 5 years. A hearing is required on all those cases. Basically, the defendant just needs to show that the harm to their privacy and the dangers of adverse consequences is things like housing, employment, things of that nature, outweigh the public interest in retaining public access to the records. This bill does have retroactive application to all eligible cases. So for us here at the district attorney's office, we're expecting to see kind of at least initial flood of these coming in for eligible cases. The sealed records are still able to be accessed by courts, law enforcement, and district attorneys. These are able to be used in other investigations as well as prosecutions as predicates. If a defendant is convicted of a new criminal offense, the court is required to unseal all priors.
How does this affect the sex offender name registration information, which is accessible to the public?
Most sex offenses are not eligible for record sealing. And you'll see that actually on the next slide when I talk about the exceptions to this. There may be some misdemeanors that would fall into a category that they could meet. There's kind of an exception to the exception where for some misdemeanors, the defendant has a very high burden of showing their need for the record to be sealed. But in general, anything that has sort of that unlawful sexual behavior basis is not eligible for sealing at all.
And those registration, the sex offender registration provisions and time periods will not change. So it shouldn't affect it at all. And even if for somehow they were able to seal a record, it shouldn't affect the registration period associated with it, although that would be silly. But most of those are not covered by this. But one of the go on.
Okay. So here are the big exceptions. You cannot seal class 1, class 2, class 3 felonies or drug felony ones. No traffic offenses or infractions are eligible for sealing. DUIs, DWAIs can't be sealed. Anything with a factual basis of unlawful sexual behavior. Child abuse is ineligible for sealing. Anything that has kind of the sentencing aggravators like extraordinary risk crimes, extraordinary aggravated offender, any crime of violence, sentencing can't be sealed. VRA felonies can't be sealed. And then the convictions for aggravated cruelty to animals, identity theft, unlawful termination of pregnancy, pandering, and then anything that has a factual basis for domestic violence. And that would be a sentencing finding. But there is an exception to the exceptions that I kind of alluded to for misdemeanors that fall under any of those other categories. So we're looking at probably a lot of like the domestic violence, DUIs, things of that nature. If it's ineligible for sealing, it still can be sealed, but the defendant has, these would always go to a hearing. The defendant has to show by clear and convincing evidence that their need is significant and substantial, and the passage of time has been such that they're no longer a threat to public safety, and that public disclosure is no longer necessary for the protection of the public.
But the scary thing is that that does mean that in a DUI offense, somebody could try to get their records sealed so that it goes off of their record. And that's scary in part because the consequences associated with DUIs are graduated upward based upon prior convictions. So that makes it harder to determine whether they have those types of prior convictions.
Well, I thought the
Well,
sealing didn't.
Yeah, the
apply to
records
us.
will still be available to district attorneys and law enforcement, and they can still be used as predicates.
Right.
So, but I question as to whether we'll be able to get them as easily as now, but we'll see. And then there's another strange provision that is, if they are reconvicted, then they're supposed to automatically unseal, although there's no mechanism in
Yeah,
place.
how we'll see that through the court is a little bit unclear right now, if it'll be, because the language of the legislation itself says basically the court shall unseal all prior sealed convictions if there's a subsequent conviction. So how we see that actually implemented through the court, if it becomes a part of their administrative record keeping procedures versus a district attorney later sees that they have gotten a conviction and, you know, we do still have sealed records. And then just as a member of the public, because there is a provision in this legislation that any member of the public can petition to have records unsealed if it's eligible for unsealing basically under the statute. And then it would be, you know, say the deputy district attorney who discovers that would then inform the court and petition to have it all unsealed.
So the criminal history would still reflect there's an arrest based upon the fingerprinting. But the court record will be sealed.
Right.
So a
There
potential
wouldn't be
employer
public
could still
access.
see that there was something on the criminal history, but not understand the dispo. Right?
The records being sealed, law enforcement will still have full access to the information as well as the district attorney's office. So you still should be able to see what the disposition is even in for any sealed cases.
But I mean, say like an employer, a
Oh, an
potential
employer will not.
who's running, you know, their daycare providers and teachers, what have you, they may see something, but then they can never
Right,
get
and
to the bottom of it.
there's no duty to this, or sort of, like, once the record is sealed, under the plain language of this legislation, they can say there are no responsive records for convictions like that. And I believe there's also some sort of provision as far as the employers looking into the records. I forget exactly what that provision said, but there are ones that address kind of that employment, looking into the background circumstances. There is one interesting one having to do with anybody employed for the Department of Education, any school teachers or anything like that. If they're petitioning to have anything sealed, they're actually required to let the district or the department know prior to petitioning for record sealing.
So other legislation that is not the subject of this actually place limits on the type of information that employers can ask of individuals about prior convictions. This makes it possible for people to seal records much more quickly. And so it's clear that what's going on here is to try to limit the use of this in employment and to minimize the adverse consequences for employment purposes of prior convictions. And one of the bills that was not covered with respect to parole is that as of, I think just a week or two ago, parolees who have felony convictions who are being supervised on parole can now vote as well. I think there was about 10,600 or so new voters were added to the voting rolls. So that was passed by the legislature also.
One thing I did want to note before we leave criminal record sealing, earlier when we were talking about the competency statute, there were all the dismissal provisions for basically after had been receiving in custody treatment. Anything that is dismissed for competency reasons is ineligible for criminal record sealing. So those records are always public. And then one of the biggest changes they did was they completely reorganized and recodified Title 12. And basically all you need to know about this is everything moved around, and there's a chart in your book that if you need to find something, it tells you where it moved to. This is mostly has to do with licensing for different businesses, entities, things like that, division of real estate. Nothing that many of us use on a daily basis. So, all right, and that is the end of the section for the legislative update piece.
So why don't we take a break and for 10 minutes, and then we will load up the case law update, and then we'll move on to that. Thank you.
You're going to get us
I really think one of those dogs would help us. Right?
they're quite basic.
In work. Good to see you. It's impressive, like.
But I know Denver was because they got place. Like some of the judges just would not even consider it. They would not consider it. On that, so.
Yeah, I think dogs, like, they tend to give us, good feelings, and I would say that as, seeing testimony, have a more positive, you like looking at dogs, it's just here.
I know. There potentially can be, but the fact that doors are pulled and they would not even, because they would bring the dog in with them before the jury would come into the room.
They never knew they were there.
Never knew they were there. It was amazing. There's clearly no bias there.
Yeah, right.
But it did provide the support, so they can minimize the potential perception of.
They're right, yeah.
Yeah.
And they're amazing.
Okay, lots of training though.
Oh, yeah. Be a good business.
Yeah, it is. Primary, thank you. I'll leave this with you. Thank you. I appreciate it.
Yep.
I gave both numbers up. And they have their ID code, each of those stick on there, so I put the serial number on the laptop in here. Then we're, it's been really easy to figure it out. Now it's case file. So when one person prints it, it knocks everyone out. So then. What's her name? Melissa Deal. She was up today working the case. So I don't know what they're gonna do because they replaced, so they wanted to say something was wrong with the laptop. So they replaced Randall's laptop, they replaced Matt's store 3 times. He's on his 3rd laptop. And then to send me that nasty, I can say that nasty.
Yeah.
It's because you tried to put the ESG file, we've been printing those, so I pulled the DMV photo, I pulled the Facebook picture. You mean we can't print those?
Snapchat's on the I've heard Snapchat. Anything good happen all the time?
No, just,
That's sad.
business as usual. Weekend before, we were complaining
Oh, no. We had a lot of rain.
well, I had to go up and refinish the grounds and I had to get a, because it had some stripes in it. It gets old. So I just resealed the whole thing and then found on Amazon because so it's so size copies on it. Before you get rolled. Find a good copy on Amazon.
That's good.
And that is all. And so now I need to do a brain break.
Oh, perfect.
Let's go read. Take on fishing on Friday. Now go back and just, you know, remind us
I had it in my car. Water fountain.
I know, I took the
And
one
then
water
I
fountain.
went to the front desk and said, is there a water fountain that works? No, there's no one. You have to be on some sort of behind the scenes access to the water. And I said, can I go up to like juvenile intake? Like, no, oh, it's not there. It's somewhere else.
Sounds like our building. All right, we can go ahead and get started, guys. So this is the case law portion of our updates. Okay, this first section is the biggest. This has to do with Fourth Amendment searches and seizures. There was a significant amount of recent case law this year for this category. Our one United States Supreme Court case for this category is Mitchell v. Wisconsin. Very recent, this one was just announced in June. Basically what happened here was, this case is out of Wisconsin. A driver was arrested for DUI. He was transported to the police station for a breath test, but he was not basically coherent enough to be able to have the breath test when that happened. The officer then took him to the hospital for the blood test. By the time they got there, he was unconscious. The officer said, ordered them to take the blood anyways, and then the defendant had a blood alcohol content of 0.222. Basically what happened is, defendant argued that the warrantless blood draw was a violation of his constitutional rights. Wisconsin replied, we have implied consent laws, which is very similar, at least, to Colorado's express consent laws. And they argued that that provided the consent for a consensual warrantless search. So basically the question before the court was then, did the blood draw of the unconscious driver violate the Fourth Amendment? The court held that it did not. This was a very weird plurality opinion. Only 4 of the justices signed on to the main opinion. The only reason that we had a definitive result in this case is because of the Thomas concurrence. So basically the majority opinion, which is the 4 of them, basically they said that the consent exception, having basically because there was implied consent under the statutes, is not a real consent for to justify a warrantless search. So a warrantless blood draw of an unconscious person. The court then turned to basically exigent circumstances. And in looking at exigent circumstances, they considered the dissipation of blood alcohol evidence as one piece of that, but there had to be some other factor. So some sort of pressing health safety need of law enforcement that together provided the exigent circumstances for the warrantless blood draw. They did say that exigent circumstances will almost always permit a blood test without a warrant for unconscious drivers. In this case, they did remand back to Wisconsin for the defendant to be able to basically show that under these circumstances, law enforcement didn't actually have that other factor of the pressing, health safety need. So the court was looking at circumstances where, say you have an accident, one person you believe is under the influence of alcohol is unconscious, but there's a lot of other duties that come along with responding to an accident scene, dealing with that. Under those circumstances, the court was like, that's always going to be exigent circumstances because you have those factors and needs going on. The Thomas concurrence, which actually helped give us the clear rule in this case, he thinks that exigent circumstances should always apply. If you have an unconscious driver, dissipation of blood alcohol is always going to be exigent circumstances. Under the dissent, Sotomayor, Ginsburg, and Kagan were all together in believing that there was, the Wisconsin was trying to go the consent route into the statutes in this case. So they said that they basically conceded that there was time to get a warrant, and if they say there's time to get a warrant, it shouldn't have been a warrantless search. And then Gorsuch's dissent was, the question presented in this case was consent under the statutory scheme, and they punted on that issue, so they should have denied cert. Here in Colorado, we have the Hyde case. Because there's no clear authority here on that consent piece, consent under our express consent statute still stands for unconscious strikers. So unless consent is revoked, they have still consented under our statutes. Because because of the fact that the Thomas concurrence took away from the plurality opinion here, that means that there's no rule overriding our Colorado Supreme Court case right now. This next one is Colorado Supreme Court case. Basically, a police officer observed a defendant parked in front of gas pumps at a gas station, wasn't pumping gas, was acting really odd. When he realized that a police officer was looking at him, he pulled up in front of the store, went into the store, came out of the store, sat in his car for a long period of time, was just acting very unusual. They came and contacted him based on his behavior. He called for another officer to come. The defendant was visibly nervous, basically told them that he, in 3 days, gone from Iowa to Las Vegas for a clothing convention or something like that, and then to Fruita. The officer found that really improbable. And then they brought a dog to do a sniff. This was one that was not trained on marijuana. The dog basically goes around the vehicle and kind of does not what they considered for the case a final alert, but an initial alert. Like basically something caught the attention of the dog, snapped around, and then came back and targeted on parts of the car, basically sniffing, but never gave the final trained indication that the dog would usually showed. The officers then put the dog in the car and conducted a hand search of the car. They found 7 pounds of marijuana and some white powder. The question in this case was basically, did they have probable cause to search the car for narcotics, even though the dog never gave that final trained indication? Here in this case, the court said yes. The dog's behaviors in that initial indication was all part of the probable cause determination to search the car. They knew based on experience with the dog, how the dog acted when they detected the narcotics, and based on that, they could use that and all of the other circumstances with the interaction with the defendant in forming probable cause to search the car. All right, in this next one, this is a Court of Appeals case. They did try to take this one up to the Supreme Court after this decision, and the Supreme Court denied cert on this. An officer observed the defendant leaving within his lane for a distance of 5 miles. At no point in time did the defendant actually commit a traffic violation. So the defendant did not cross over the lines or do anything illegal. And then after 5 miles of watching this kind of going back and forth within the lane, pulled the defendant over, finds that he's been drinking, and his license was revoked as a habitual traffic offender. So basically the question in this case was, can that not committing a violation but weaving within a single lane for a distance such as 5 miles actually create enough sufficient reasonable suspicion for an investigatory stop? And the court here said yes, it could. Even though there wasn't a violation of the law, because of that length of period that was able to add to the circumstances. So the officer was able to form reasonable suspicion. Because it wasn't a, little bit of weaving within the lane that they observed. This was a continued, pattern of weaving over a long period. All right, so this next one, People v. Thrickle, I think that's how you pronounce it, is a Colorado Supreme Court case. This one came out in March of this year, and basically just has to do with reasonable suspicion for a stop. There were two people defendant here, and her significant other, Alan. They were the subject of a narcotics investigation. There were arrest warrants out for both of these individuals. Law enforcement observed the truck sitting outside the residence. It was kind of a determined thing they were going to arrest these two, act on the warrants. The truck left the residence. It was followed by law enforcement. They attempted to stop the truck, and the truck then sped up, tried to drive away. They saw a bag thrown out of the front passenger window. Then a little later, they're finally able to stop the truck, but when they stopped the truck, there's only one person in the truck. It's only this Allen individual. Defendant wasn't present. Even though they'd seen something thrown out the passenger window, believed both of them had been in the truck together. Well, another deputy finds a female a couple hundred yards away from the truck trying to hitchhike through the community. It's a snowy night. No clear pathways from the house to that part of the neighborhood. She's very close in location to the truck. Just based on the circumstances, they believe she's associated. The deputy who actually stops her visually recognizes her as the defendant and that she has a warrant for her arrest, and then goes ahead and arrests her. The question here was they challenged the stop and tried to suppress everything that happened after that because they didn't have sufficient articulable suspicion to stop her at that point, because she could have been anyone at the side of the road. Well, this case looked a lot at the fellow officer rule and how that imparts knowledge, that the knowledge that the law enforcement acting as a concerted group to basically arrest both of these two, and even though maybe one deputy, and here it was the testifying deputy. So when the court suppressed this evidence, the court really didn't like the fact that the deputy testifying was not the deputy who actually arrested the defendant. But the Supreme Court said no, that was fine. It didn't have to be the deputy who arrested her who then testified for the suppression hearing. An officer is entitled to draw all reasonable inferences from the circumstantial evidence. So basically the knowledge that law enforcement had, each of those officers doing their piece of this, the ones following the truck, pulling the truck over, only finding the significant other of the defendant inside there, observing that bag being thrown out of the passenger window, leading them to believe that a passenger had been in there, and then she's found in very close proximity to the truck, cold snowy night when there's no clear pathways in the area. All of those things together, even though maybe one single officer didn't have all of that knowledge at one point in time, was still sufficient for the stop. All right, this is another Colorado Supreme Court case, People v. Davis. This one, the defendant's arrested on suspicion of first-degree murder, and when he's being interrogated, he basically asks the interrogating officer to call his girlfriend because he had driven to work in her car and he wanted her to be able to come and pick up the car. So in asking the officer to call his girlfriend, he gives the officer the passcode to his cell phone. The officer decides not to call the girlfriend at that point in time. Defendant then asks later, again, if they'll call his girlfriend, gives the passcode to them a second time. Later on, they obtain a warrant to search the phone, and when they get the warrant, they use the passcode provided by the defendant to access the phone and then follow the warrant, execute the warrant. So the defendant here argued that the Fourth Amendment prevented them from using the passcode, since he'd only given it to them to call his girlfriend, and they then used it to search his phone, that this was an unconstitutional search. So the question here was using the passcode to execute the warrant permissible? And the court said yes. This, at the district court level, this evidence was actually suppressed. The court evaluated it basically as a consent search rather than a search pursuant to a warrant. And in looking at it with that consent piece of it, they said, wait, there was only limited consent here, but the warrant was the piece that actually gave them the authority to search the phone. So the Supreme Court looked at this from the aspect of the passcode giving them the ability to access the contents and the warrant giving them the authority to do so. In the fact that defendant willingly gave up the passcode to the law enforcement officer, that third party, he then didn't express a reasonable expectation of privacy in that information. So law enforcement was able to use that to access the phone.
So, even if someone refuses to give you consent to search the phone, you might want to just ask them, hey, what's the passcode today?
Yeah.
We have that so we can make a record of that for your property, and then go get the warrant. Yeah. Okay.
If you can get the
Yes.
passcode,
If
it'll
you
be
can
a
get
lot
the-
easier to access.
That's right. If you can get the passcode, you might be able to actually then get into the phone.
Searches of phones generally are always going to require a warrant. But this makes it easier to get into. All right, these next two cases are very similar and kind of fun. These basically have to do with pat downs. And in both of these cases, it's basically late at night. In this first one, defendant's stranded in the cold, vehicle's inoperable, trying to get gas or some sort of assistance to get his car working. An officer offered to give him a ride, but basically when he said, yes, I need a ride, said, hey, I'm going to have to pat you down it's an officer safety rule, have to do this before you get in my car. Same type of situation in the second case here, Gal v. People. Defendant's walking through a neighborhood about 2:30 in the morning carrying a box, so law enforcement, the officer was curious as to what he was doing, pulled over, asked him, what are you doing, everything okay? The guy identified himself, said he was just coming from his friend's house, he just bought an iPad. Officer, gets his identification, clears him, says, okay, have a good night. The guy continues walking down the street. The police officer pulls up to the intersection and sees him, kind of still walking down. And then the defendant actually flags the officer down and says, hey, can you give me a ride to my friend's house about 4 blocks away? It's late. Officer says, yes, but I'm going to have to pat you down before you get into my car. And then in doing that, he found bags of speed and meth in the box with the iPad. In this first case, the defendant didn't give express consent, didn't say sure or yes in response to the pat down question. But what he did was he went to the car, turned around, and put his hands on the trunk of the car and spread his legs so that he could have the pat down search. The officer then found meth in a pipe in his socks, or on his ankle, basically. So the question in both of these cases were these pat downs constitutional? Court held yes in both cases. These were both consent searches. Even though the circumstances, particularly in that first case, the Berdahl case, may have been more out of necessity for the defendant, the cold, broken down vehicle, there still is not coercion or anything that would override his consent for this search. So an objectively reasonable person would have understood that they're being frisked for officer safety before you get into the car, and they consented to those searches in those circumstances. All right, this next one is another Colorado Supreme Court case. Kind of interesting circumstances. Defendant goes and checks himself into a hospital after extended drinking because he's having symptoms of alcohol poisoning, alcohol withdrawal, something like that. Treated briefly by hospital staff and then decides he's going to leave. The doctor then called law enforcement to report that this guy has left the hospital and he got in his truck, and the doctor and one of the nurses watched the defendant drive out of the hospital parking lot in his truck after they told him, you know, you're still under the influence, we need you to stay here for treatment. So officers go to respond to his address. They find him outside of his house getting out of the truck with the lights on. Defendant claims that his friends brought him home and he was only going to the truck to look for cigarettes. They talk as defendant is kind of walking around outside his house on his patio. He does admit that he had been drinking and that he knew that he wasn't safe to drive, but that friends were the ones who had driven him from the hospital. The defendant enters and exits the house several times. The officers finally follow him inside the house on one of these, trying to tell him, you know, come back outside, you know, we're trying to have a conversation with you. While they're in the house with him, one of the officers detects an odor of alcohol on him. Then they finally get him to come out of the house. They asked that he do field sobriety tests. He does agree to do them, and then failed the HGN and failed to do them as a sober person. Then he did submit to a blood test as well. So the district court found the entry into the home unconstitutional, said that there was no reason the officer should have followed him into the house at that point in time. But what the district court did was they did not consider the independent source doctrine in their findings, and the Colorado Supreme Court basically reversed on that basis. So because of what they knew in the investigation leading up to the point when they entered the house, and the only evidence they gained in that house, you know, with the illegal entry was the odor of alcohol. Would they have still conducted those field sobriety tests after, you know, on getting the defendant back out of the house, regardless of what they learned in the house? So that's what the court was looking at. And they looked at the fact that they already had probable cause to arrest the defendant for DUI before they even walked into his house. They had the report of the doctor and nurse from the hospital. You know, they saw hospital staff saw him get into the truck, police saw him get out of the truck, suspected that he'd been drinking, and they did, the court remanded this back down to the district court to see how much of basically the field sobriety test, blood test, how much of that was actually triggered by, you know, merely the odor of alcohol they learned inside the house. All right, this next one has to do with reasonable suspicion for a stop. This is another Colorado Supreme Court case. A patrol officer is out and hears two people, a man and a woman, arguing behind a gate at a storage facility. He calls it into dispatch. Dispatch tells him that they just got a call from the area of the storage facility. Woman reported she was in this dispute with her significant other, and he had damaged the windshield on her car. So he gets off the phone, or off with dispatch, and he was also given the name of the significant other, Alexis Brown, who's the defendant here. He's given his name from dispatch. So once he gets done with them, he listens and he doesn't hear the argument going on anymore in the storage facility. And then he sees a man come walking by, and he confronts the man walking away from the area. It was the only visible person in the area, asks for the name, and gets the name that he had learned from dispatch, which was Alexis Brown. The trial court suppressed all the evidence, saying that he didn't have reasonable suspicion to stop him. The court disagreed. He said that he did have an articulable basis for suspecting that individual being part of criminal activity based on the circumstances. So hearing that arguing within the storage facility, him, once he got done with dispatch, there was no continuing argument, and he sees this man leaving the area. He did have suspicion, since that was the only person in the area, that that was probably the person involved in the domestic dispute. All right, this next one, another Colorado Supreme Court case, People v. McKnight. So the officer here sees the defendant parked in a truck in the wrong way of a one-way. Defendant moves from where he is, officer follows him. They see the defendant park outside of a house where they found drugs in the past. Didn't see anyone leave or enter the vehicle. Finally, he pulls the defendant over for failure to use a turn signal and recognizes the passenger of the vehicle, not the driver, as someone who he knew had used meth in the past. So based on this, he calls for a drug dog, and this dog is trained in meth, cocaine, heroin, ecstasy, and marijuana. And this is after marijuana has been legalized here. The drug dog does alert, and the police find a meth pipe with residue. Defendant moves to suppress the evidence, arguing that the use of a dog trained in marijuana that is not enough to establish probable cause for a search because it's legal. So the court held that use of a dog trained in marijuana is a search that requires probable cause. And dog sniff cases in the past have always hinged on that idea that there's no reasonable expectation of privacy in contraband. So because for people 21 and up in the state of Colorado, because certain amounts of marijuana have been legalized, and drug dogs can't tell the difference between a legal amount or illegal amount of marijuana, then there is a reasonable expectation of privacy in the detection of something that is lawful for an adult person to have. So that's why the court concluded here that that's actually a search, as opposed to past dog sniff cases where usually it's been maybe they only needed reasonable suspicion, or it's been a kind of incidental intrusion on privacy. Now it's something more when the dog can detect lawful activity. And this decision is obviously based only on Colorado's Constitution. All right. This next one is another Colorado Supreme Court case. It's the state trooper pulls over a car after seeing the driver just kind of blink their turn signal a couple times over a distance of less than 200 feet prior to changing lanes, and this is on a highway. Defendant was the passenger in the car. During the stop, the troopers find evidence for drug possession with intent to distribute and possession of a weapon by a previous offender. So basically the question here was if the stop was lawful. So it is actually not a traffic violation to fail to use your turn signal 200 feet before changing lanes. It's only required for a turn. So in the city, it's 100 feet before you make a turn. If you're on a highway, it's 200 feet before you make a turn. There's nothing in the statute that gives a distance requirement for changing lanes. It just says you have to use your blinker. So because this isn't an actual requirement, and the plain language of the statute only requires it before a turn, They found that it wasn't a lawful stop. The prosecution did try to argue that it was a good faith mistake of law, that the officer, believed this. And the Department of Revenue's driver's manual actually included the same information, that it had to be, 200 feet before changing lanes. But the court pointed out that there wasn't any evidence presented that the officer ever actually relied on that driving manual. And that because the statutes here, really weren't ambiguous in any sort of way, the manual even says that it's not a book of law and refers you back to Title 42. Like there was no good faith mistake of law here. And the stop and everything had to be suppressed because the stop itself was unlawful. All right, this one was a Court of Appeals case and came from a car accident. The defendant backed into a truck, and then when he got out of the truck, there was a kind of bystander witness there, and he asked them that if they wanted his beer because he needed to get rid of it before someone responded to the accident. Officer arrives on scene. The defendant performs poorly on roadsides. So he's arrested under express consent, given the choice between breath and blood. He chooses the breath test, and it comes back with a 0. The officer then requested a blood test, thinking that, okay, he's under the influence of drugs and not alcohol. Blood test shows 101 nanograms of Xanax per milliliter, which is at basically the upper end of the therapeutic range for that drug. And they challenged it, saying basically under the express consent statute, we chose the defendant chose the breath test. You had no authority to then turn around and order the blood test. So the question here for the court was basically, can the officer invoke the express consent statute after that initial test has already been done? And the court said yes. There is nothing in the statutes that prohibit the officer from doing that. Once the breath test showed up negative, the officer then had probable cause to believe that the defendant was under the influence of drugs. And then under the express consent statute, they could require it's like blood, urine, hair, I think. As kind of a sub-issue in this case had to do with the toxicology report. The court basically said that even though it's somebody maybe not who didn't do the initial testing on it, if they're acting in a verification and supervisory role, then they're still able to testify to the results. This next one is a Court of Appeals case. Very big case. There are a lot of issues in this one, but kind of the most law enforcement applicable piece of this had to do with the interrogation issue. So basically what happens is police respond to what's been called into them as a menacing incident. A guy on a motorcycle was following somebody else. They claimed he was brandishing a firearm. That person later calls 911 again and says, wait, maybe they didn't have a gun. But law enforcement responds to the area. They did locate the defendant at a house. They saw the motorcycle parked in front of a house. They initially thought somebody else was the driver of the motorcycle, so we're questioning somebody else. And then the defendant came out of the house and said, wait, no, I was the driver of the motorcycle. I was the one on it. And then he appeared intoxicated. Everybody basically was very nice, friendly, getting along. The officers, when they testified at the suppression hearing, basically said they didn't have any concerns about the defendant or the other person they were questioning. But still, they decided to cuff the defendant and put him in the back of the cop car while they were basically questioning a few other people. And they had already determined that he didn't actually have a firearm on him. So in this case, the prosecution conceded that there was no probable cause to arrest him at that point, and the arrest was illegal. But then about 11 minutes later, defendant was taken out of the patrol car and the handcuffs were removed. He was Mirandized, waived his rights, and then made statements to the officers about how much he'd been drinking before he got onto the motorcycle. So basically here, they were trying to suppress all the statements that he made about how much he had to drink, saying that, wait, all of this came after that illegal arrest being placed in the back of the patrol car, and so would need to be suppressed. The Court of Appeals was looking at whether these statements, after 11 minutes, were sufficiently attenuated from the illegal arrest to still be admissible. And the court said yes. So the court here basically didn't find that the time limit, even though it was such a brief time, that wasn't as important as some of the other factors that were present here. So the intervening circumstances were probably the most important piece. So before he was interrogated, he was actually taken out of the patrol car. They removed the handcuffs. No weapons were present. He was Mirandized and waived his Miranda rights. So even though it only happened 11 minutes after him being placed in the patrol car, those factors, you know, being taken out, no handcuffs, they're talking, no weapons, that was enough to kind of break the chain from their illegal arrest. They also were looking at, you know, kind of why he was placed in the patrol car. And they said that they were aimed at investigating a possible weapons offense, and even though they didn't actually find a weapon on the defendant prior to putting him in the car, it was still, you know, part of a permissible, for a good reason, investigation, and that helped with the attenuation factor. All right, so I'm going to turn it over to Steve for this next section.
So moving on to the Fifth Amendment, Miranda and in custody. Our first case we'll talk about is Marco versus People. And so this happened down in Colorado Springs, and the defendant was stationed at Fort Carson. Military police picks him up and transport him in handcuffs to interview with the civilian police, with the Colorado Springs Police Department. Upon being picked up, the defendant's asked if he was under arrest, and MPs told him he was not, but this was just normal base procedure. That is, this is how they were required or how they transported people under these circumstances. When he meets with the civilian authorities, his handcuffs are removed. The officers tell him he's not under arrest and that he's free to leave. The defendant indicated that he understood and he agreed to talk. After repeatedly changing his story and being confronted with messages between him and the victim, he admits to a sexual relationship and that he saw her on the day she disappeared. And the officers then Mirandize the defendant, and then he confesses to incapacitating, sexually assaulting, and murdering the victim. So the question is, was the defendant in custody prior to being Mirandized? Because if he was, then that would be custodial interrogation. It would require Miranda warnings, and those initial statements would have been suppressed, and arguably that would have then tainted the subsequent statements. So that was an issue. And the court said no, that whether someone is in custody is determined by whether, under the totality of the circumstances, a reasonable person in the defendant's position would feel that he is not at liberty to terminate an interview and leave. That says while military command structure is relevant, it's not the controlling factor. That there was no evidence that the defendant had an express order to speak to the civilian authorities. He was only ordered to report with the MPs to the provost military office to meet with the civilian police. The transportation in handcuffs was standard-based practice, not due to request by the civilian police. And the MPs did not participate in the interview or even remain in the room when it commenced. And probably the factor that, looking back at the facts, that was probably the most important was the officers told him he was not in custody, told him he was free to leave. And so under those circumstances, even though the situation started under circumstances which one might suspect were custodial in nature. The actions by the local law enforcement broke that assumption and allowed for a claim to be made that he was not in custody. Don't know how this would have been decided in the absence of that type of advisement, that type of statement, but that was part of the facts, and that led to this good result. People versus Barrios. And juvenile and the defendant and guardian signed an advisement and waiver for the defendant's right to have a guardian present. The defendant was properly Mirandized. The cops minimized the charges. On the forms, instead of saying car theft, it said taking victim's car. Instead of saying menacing, it said carrying a knife. Instead of sexual assault, it said touching. And the actual charges included kidnapping, aggravated robbery, and sexual assault. The defendant moves to suppress the statements because of an unreliable waiver, claiming the charges were minimized and the defendant did not consult with a guardian. So, was the defendant's parental presence right properly waived? And the court said yes. The advisement and waiver listed the parental presence in both face. The defendant verbally was advised of parental rights in addition to Miranda. He was told he could stop at any time. The defendant's waiver was done knowingly, voluntarily, and intelligently. And although the charges were minimized, they said that the guardian knew this was a serious matter because of the SWAT responding, and her only question was if the defendant killed anyone. And when the answer was no, it was all right then to question it. Lack of consultation is only one factor. Furthermore, the defendant and guardian had the opportunity to consult, and both waived. And so the guardian was offered a ride, told her presence was ideal, but she still waived. And so the defendant was told he could stop at any time and have parental presence. So they did what was required under those circumstances, and the statements were not suppressed. People versus Perez. And the defendant was a passenger in a car that's pulled over. When he provides a false name, he was asked to step out of the car. He attempts to flee. The officers did not see him conceal or discard anything. After he attempts to flee, he's handcuffed and frisked. The officers then find shotgun shells in his pockets. This was the sole reason that they thought that he might have abandoned a gun. Before Mirandizing the defendant, the officer asked, "Where's the gun?" The defendant responded that he had thrown it away. The shotgun ultimately is found in the car, and so he wasn't being honest about that. And the prosecution argues that public safety exception applied so that he did not need to be Mirandized under these circumstances. So did the public safety exception to Miranda justify asking about a possibly abandoned handgun? And the answer was no. So the guy was clearly in custody. And then the officer asked him, after he found the shotgun shells in his pocket, about where the gun was. And that's when the statement was made. And they said that there was nothing about finding 2 shotgun shells in the pocket of a suspect which would necessarily implicate the public safety exception. There was no reason to believe that a gun was discarded or placed in a public location where it might have posed danger to someone, as opposed to in the car where in fact it was. And so under those circumstances, those statements were suppressed as being custodial interrogation without a Miranda warning. Identification procedures. So People versus Godinez, it's actually a good case for us. A sexual assault victim said the defendant looked like her attacked her, but wasn't totally sure when viewing a photo lineup. In court, the victim was able to identify the defendant as her attacker. The defendant's convicted. The appeals on the grounds that the previous photo lineup was impermissibly suggestive and that the in-court identification was impermissibly suggestive because the prosecutor told the witness to look to her right. And the defendant was the only teenage Hispanic male in the courtroom. So that's the issue. Was the victim in court identification permissible? The answer was yes. The parties had stipulated that the victim was unable to ID the defendant in a pretrial photo lineup. And there was no evidence that the photo lineup was impermissibly suggestive. And it's the defendant's duty to show that it is impermissibly suggestive in a challenge. The victim was first to raise the ability to ID during direct, and the prosecutor followed up, look to your right. So, so there was some dialogue about them in terms of where she should be looking, and he just directed her to look at the defense table. It is up to the jury to determine the credibility of witnesses, of victims in-court ID. And the jury was informed that the victim was unable to ID in pre-court photo lineup procedures. The defense counsel had the opportunity to cross-examine. The defense did cross-examine about circumstances for in-court ID, including the fact that the defendant was the only teen Hispanic male in the courtroom. So, the bottom line is that the jury saw the entire identification. They were given all the facts, and the Supreme Court said, hey, this might go to the weight, but not the admissibility of this identification. And so since the jury had all the information, they could decide whether or not this in any way undermined the ability of the victim to make the in-court identification. Crimes and elements. People versus Coran. The defendant and ex-boyfriend have an argument in the parking lot. When the defendant tries to walk away, the ex grabs her wrist. She was worried that the situation would escalate, and so she kicked the defendant, not in his privates, but kicked his car, and to distract him and gain leverage so that she could break away. The court denies her request for a self-defense instruction. And so the trial court reasoned that self-defense was not available as an affirmative defense for property crimes. Okay? And she was charged with criminal mischief. So, can self-defense apply to criminal mischief against property? Kind of an interesting issue. And Colleen and I actually talked about whether we should include this, or is this like inside baseball? Is more to do with DAs. But I thought that, well, this is a fact pattern that might reoccur in law enforcement. That is, when a victim is trying to protect herself and decides to damage something of the defendants that they may value. So we included it for you. The answer is yes. That the legislature intended to allow victims to use self-defense. Not allowing self-defense for actions against property would create a perverse incentive. Persons in the defendant's situation would be encouraged to direct physical force against the person. It'd be all right to kick the defendant and actually hurt him, but you can't kick his property in order to distract him to achieve the same result when that's what you're trying to do. And this is inconsistent with the legislative mandate to use only a degree of force which she reasonably believes is necessary to defend herself. Arguably, it's a lesser degree of force to kick the property than it is to kick the defendant, right? In some circumstances, such as this, reasonably necessary may involve defensive actions designed to affect the other person indirectly or to cause a reaction, which in turn causes property damage rather than physical injury. So kind of an interesting case, and the rationale does make some sense. People in the interest of district court. A juvenile is committed to the Division of Youth Corrections, and he exposes himself in class. This probably happened right next door, okay, at Lookout Mountain. And public indecency statute requires exposing oneself in a public place or a place where reasonably expected members of the public may see. The prosecution says the DYC classroom is a public place. The defense argues that the classroom is not a public place, and DYC residents, teachers, and staff are not members of the public because they are assigned to live there or employed. In other words, they say it's a prison. It's not a public place, and most people had to do something to get in. They just can't come in whenever they want. Oops. So, oh, did I jump
I
ahead?
think you were right there, yeah.
Okay, right there.
Yep.
So the answer is yes, that this charge was appropriate for two possible reasons. But one is the statute had two different ways to commit it. And so they don't decide the question of whether this is a public place. Because I say we don't have to decide that, because we decide that these are members of the public who are attending class, and the teachers and other people who are there. And they're members of the public, and he exposed himself to these members of the public. Therefore, he committed the crime, and we won't decide the issue of whether this is a public place or not, because we're not required to do so in this case. People versus Ramirez. A foster parent, and this is the case I mentioned to you before with respect to the change in the law with respect to sexual contact and that is an ejaculation. Foster parent ejaculates into the minor's hand and made them drink the semen. The defendant was convicted by the trial court of sexual assault on a child, sexual assault on a child by one in a position of trust, and indecent exposure. The Court of Appeals overturns it, finding that ejaculation did not fit under the Colorado statute defining sexual contact. And House Bill 19-1115, that we already talked about, now corrects that to change the definition.
One quick thing that's actually interesting about this case, this happened while I was at the AG's office, and they did an expedited petition for cert on this case to try to get the Colorado Supreme Court to take it, and it was almost an instantaneous denial of cert on this case. So the Court of Appeals decision was the final say on it.
So they didn't find anything sufficiently offensive.
Yeah, it should be for about the definition of sexual contact.
Right. And People versus Murray. A couple breaks up. 2.5 weeks later, the defendant asks him to come over to help with groceries. The victim owns the house, permits the defendant to live there, come and go as he pleased. The two get into an argument, and the victim told the defendant to leave. The defendant threatens the victim, takes off her clothes, attempts to sexually assault her. The defendant leaves to chase off another friend of the victim's. The victim locks the door behind him and calls 911. The defendant yells at the victim to let him back in. When she refuses, he breaks a window on the front door trying to get in. Was the defendant a tenant at the victim's home so that his entry or remaining at the premises was lawful? So, in other words, could he be charged and convicted of burglary or criminal trespass under those circumstances? The answer was no. A person can be convicted of burglary if previously granted, well, the answer no, or is it yes? Oh, no, if he was not a tenant. Yes, he can be convicted of those things, yes. So he was not a tenant. A person can be convicted of burglary if previously granted permission to enter is withdrawn, and the person enters or remains on the premises with the intent to commit a crime therein. And so the victim, if she owns the premises, can withdraw permission. There was no tenant agreement between the parties, written or otherwise. The defendant did not pay rent. Mere contribution to groceries, etc., is not enough to create tenancy. The defendant was not granted exclusive possession of the premises in exchange for rent. The defendant's possessory interest was not equal to the victim's and was subject to the victim's continued consent. Increased possessory interest by locking the doors. And so what was important here was that she was a primary tenant. She was the one on the lease. She's the one who's paying the rent. And said under those circumstances, she could terminate his right to be there. She could exclude him, and then his re-entry under those circumstances would constitute a trespass. Now, the facts, of course, might have been quite different if they were both on the lease and both had equal access to come and go. Probably this case gets decided differently.
Question.
Yes?
I'm wondering how important it was that he's entering again with the intent to commit a crime, because as I understand it, we're trained that whether or not a person is on the lease, whether or not they're paying rent, by Colorado law, they establish residency after, I think it's 30 days. And in order to kick them out of the dwelling, you need to evict them.
So, so of course, that's a little, eviction stuff is a bit different than criminal stuff. And so, it depends on what the statute you're talking about. Burglary applies to unlawfully entered or remained, okay? And so, if the person's there and she says, you must now leave my place, this rule would probably apply equally, okay?
So if we're called because they let someone stay in the house, he's lived there for a couple of years, now the relationship is broken up, they're ordering the person to leave the house, they're refusing to leave.
Now
And
remember,
they call us and say, well, he won't leave, I want him charged with trespassing.
well, that's not trespassing, because a trespass is if they unlawfully enter without permission. He's already there, okay? And so he didn't unlawfully enter under your facts scenario, okay? Burglary deals with unlawful entry or remainder, and with the intent to commit therein another crime, if you see what I'm saying. So, but yes, it might be a trespass if once he left, she said you can't come back in. And so that would be the question, would that be a trespass? And so your answer to her might be, well, if there is a dispute as to who has correct or lawful possession of the premises, I might not be able to charge a criminal offense. Okay? You might not have sufficient information under those circumstances. So you'd have to evaluate these same types of things and decide, is she the tenant? And so as to exclude it. And so there may be a difference between eviction law and the question of whether to charge somebody with a criminal violation. And in this case doesn't answer that. But it's a good question there. And People versus Houston. The defendant and a girlfriend break up. This is a similar type of case. The defendant moves out, but stayed frequently and kept some belongings there. The defendant knocked down the door to get back in. Assaults the girlfriend. The defendant is convicted of second-degree burglary. He claims he was invited by the victim, also claims a possessory interest. Was there sufficient evidence for a reasonable juror to find that the defendant knowingly entered the dwelling unlawfully? And the answer was yes. The victim testified that she did not remember the invitation. So he said, she invited me. She said, I don't remember inviting him. And a reasonable juror could find her more credible than the defendant. The defendant, and this is really the key here, the defendant gained entry by kicking down the door. And this method of entry is inconsistent with any kind of permissive entry. And so, if she locks him out and he kicks down the door, it's going to be pretty hard to argue that I was invited or permitted to be in the house. Although he continued to stay frequently, he had already taken many of his belongings out of the apartment. The defendant always knocked before entering the apartment because he didn't have keys, which suggested that he did not have a possessory interest in the apartment. And the defendant gained entry by kicking the door down. This method of entry is inconsistent with any kind of permissive entry. Now, note that they don't decide these rules as a matter of law, that this is the way it is in terms of trespass or not. But what they're saying is that the jury on these facts could find him guilty of burglary or trespass. And so that's the decision that they're making. That is, the evidence would support those types of findings. A reasonable juror could have easily concluded that the defendant knew he did not have permission to enter the department. So they're not making that decision as a matter of law. They're simply saying this was a factual issue for the jury to decide, and their decision in this regard is supported by evidence. People versus Hodge. The defendant and a 14-year-old victim met online in a chat room. They discussed bondage and sadomasochism and devised a plan to have the defendant pose as victim's friend's parent. The defendant placed padlocked collar around the victim's neck, handcuffed the victim's hands behind his back, placed a ball gag in the victim's mouth. He then proceeded to sodomize the victim. At a preliminary hearing, the court rejected the Class 3 felony sexual assault against a child with force used to facilitate sexual contact because the undisputed evidence showed that the victim consented to restraints. The prosecution appealed. Was there sufficient probable cause to believe the defendant used force to facilitate sexual contact? Answer is yes, because this is sex assault on a child, and consent is irrelevant. And as such, consent is also irrelevant to the force part. Child cannot consent to sexual contact under this period, and therefore cannot consent to sexual contact under circumstances where there is violence or force involved in the sexual contact. Use of force does not need to be non-consensual to charge an F3 child sex assault instead of an F4. People versus Den Hartig. During a traffic stop, the defendant reverses his car without warning, injuring a motorcycle police officer behind him. The defendant is charged with first-degree assault on a peace officer. And an element of that crime is that the actor threatens the victim. Prosecution argues that threaten includes any action that places the officer at risk of harm. The defense argues that the threaten requires some communication of intent hostile. Did the defendant threaten the officer and satisfy this element for first-degree assault? You all think yes, but unfortunately the Supreme Court of Appeals held no. They said the court held there was insufficient evidence for first-degree assault. There was sufficient evidence for second-degree assault. The act of reversing the officer on its own was insufficient to say that that was a threat. The court notes that there would be circumstances where a vehicle could be used as a deadly weapon to threaten. They also do not foreclose an interpretation that includes nonverbal communications. But they said that on these facts, they did not find that this constituted first-degree assault, as opposed to second-degree assault.
So if they just assault you right out of the blue with no warning, then they can't be charged with first-degree assault?
Under the reasoning of this case, and I was also at the AG's office when this one came out too, we couldn't really believe that they had taken kind of the stance on a threat, because we couldn't really imagine, much more of a threat than a vehicle, coming right at you, right? But their reasoning really didn't shut down the idea that it can be non-verbal, but they were looking at some sort of warning action to be a threat. They wanted some sort of more time to go by. I think there was more of a temporal
I am going
element
to
to
stab
this.
you with this
Like,
knife. and
Maybe
then-
if you
Well, that's
see the
easy.
vehicle coming from
Yeah,
further
that's
down the
easy.
block or something like that, but the way that this happened in such a short proximity, they didn't really find that that could be enough to have threatened the officer.
So in
No,
your
no, that's-
situation,
that's-
so
no,
immediate.
You take my meaning wrong. My question is, are they saying in order to go first degree assault against a police officer, I have to say, I am going to stab you with this knife and then stab you? What if I just stab you?
so they're not saying anything in particular in terms of giving us better guidance, other than to say that there could be circumstances where a threat is made, and but that those circumstances aren't in that case. And so what they're saying is there has to be something other than just the physical action. And so something of a verbal threat or non-verbal threat before the assault to indicate that that is the intent of the person, or that's what they are threatening to do. That's what they're saying, but they're not telling you what that something else has to be. So clearly if somebody announced, like your example, that'd be easy, right?
Right, but so if I just stab you and I don't make any kind of threat beforehand, then that doesn't count?
That may
That's
not,
what you're saying?
I think the presentation of the weapon would be threat enough.
Yeah,
I
and
mean,
that's
all
what I
that
was gonna say there. I mean, I don't think
your
this
observations.
doesn't foreclose any sort of non-verbal threat. It really doesn't. And that's the problem with, Court of Appeals and Supreme Court cases. They're limited to the facts that are in front of them. And they don't, they aren't making broad statements about all kinds of things. They just hear. And I really do think that that kind of time element was such a big piece of this. It's just that there really wasn't, they didn't think that in that quick act of reversing like that there was just enough to process a threat, even though most of us disagreed on
Just like
that.
in the quick act
But-
of stabbing Dutch with a knife,
I
there's
mean,
no
I-
time involved.
And I don't know if maybe it's the type of weapon or something like that, but I mean, until those other facts are kind of presented to the court, we really don't know and don't have further clarity on that. I believe they are seeking, I haven't looked in a long time to see where it's at, but I believe they are seeking cert on this case as well.
and I have a Lakewood double vehicular homicide going right now, where before the Officer David Salito's car was rammed twice by the suspect. And I've charged second-degree assault, but I did not charge first-degree assault, in part because of this case. Now he's charged with lots of other things. But you're right, it is kind of problematic. And I think that if a car drove at the officer for an extended period of time, distance, that you could say, well, this was a threat before he hit the officer, right? But this is the court's decision on this particular set of facts, saying what happened in reversing was not a sufficient threat to make it a threat under first-degree assault, even though there's still a felony second-degree assault. Right. So we have to kind of live with that unless the Supreme Court tells them that they're out of line. And we're just presenting these things. We don't necessarily agree.
What's the messenger?
Yes.
All right, we are nearing the end. This last piece is witness testimony. All has to do with law enforcement expert testimony. So we've got about 3 cases on this. The biggest one, Colorado Supreme Court, just here in June, they did find that testimony about the horizontal gaze nystagmus, sorry, the test is expert rather than lay testimony, which is going to change a lot of the process for law enforcement testimony on field sobriety tests, because there are disclosure requirements that go along with expert testimony. CV has to be given, disclosure of what the expert opinion is going to be prior to trial.
And we've already started, with respect to many of the law enforcement agencies, we've asked the traffic officers to give us curriculum vitae resumes detailing all their experience and their training. And that's part of the reason why. And we've generated a standard horizontal gaze and nystagmus type of expert to give out in order for us to comply with this. But as you'll see here, and from last year's cases, this is a growing trend. And that is more and more times we're saying officer testimony, if it involves specialized knowledge or experience, the fact that you guys have a lot of training, that you have a lot of experience that goes beyond what the average person would have, it's going to require that the person be qualified as an expert. And the big thing there is that they be endorsed, and that we provide a resume, a curriculum vitae, because those things are required by the court or by the rules of evidence.
Right now, this is limited, as far as the field sobriety test goes, it is limited to the HGN test alone. What will happen as far as, testimony regarding other pieces of the road science, I think that the argument still stands for a lot of the roadsides that it is, ordinary perceptions as far as, walk and turn and things like that. This one is, the main reasons that they found that this test specifically was expert testimony was really just because a layperson, an ordinary person in the community would not have the knowledge that a person's eye will react like that under those certain circumstances or when under the influence of drugs or alcohol. So based on a law enforcement officer's specialized training in how to the administration of that test, they've gained skills that an ordinary person, yes, well, an ordinary person can see that somebody's eye may not be, tracking normally or something like that. They don't know how to interpret that. And that's a key piece of why, that law enforcement testimony is kind of broaching that line for expert. And I mean, a lot of times when DAs are eliciting this testimony at trial, they're asking them, continually to talk about their observations, and their conclusions based on their training and experience, and that is because they do have that specialized training.
You ask yourself, before you were a police officer, when you encountered somebody who was drunk, did you know someone was intoxicated?
I ordered it, so
Yeah, or because of the way they were acting, right? But before you were a police officer, did you know anything about horizontal gaze and nystagmus? No. And that's the distinction. I mean, this is something that is outside of people's normal understanding. The case law says any person can opine as to whether someone's intoxicated based upon their basic life experiences.
Right.
But not with respect to something that requires technical knowledge and training.
And these next two are kind of in that same sort of vein. In this first one, the defendant was pulled over, seen with an open beer in his hand. He claims that he actually only drank after he parked. There were also empty containers in the car. They did not take a breathalyzer, but the officer at trial testified that he had an odor of metabolized alcohol. And then he also, in response to a jury question, the juror asked if they could tell, if he could tell based on that odor if, the defendant had been drinking there in the parking lot or if it had been earlier in the day. Well, the officer then explained that the odor smells different depending on like how much they had to drink, how long ago type of a thing, if it's strong or faint. And basically said that the odor that he smelled was consistent with the number of empty beers found in the car, the empty beer cans in the car. He did testify as a lay witness at trial. This next one had to do with a juvenile. The defendant here wasn't a juvenile, but a school resource officer contacted a juvenile who was acting strangely in school, found out that they had been to a concert the night before with an older step sibling who was an adult and had taken meth. In doing an investigation of basically questioning the juvenile, finding out about the defendant Murphy in this case, Murphy was charged with distribution of methamphetamine. The officer testified that during his questioning of the juvenile, based on the juvenile's behaviors exhibited, he knew that the juvenile was being deceitful with him. At trial, the juvenile actually did recant basically all information because it was a sibling. So they relied very heavily on the officer's testimony about the earlier interview of the juvenile and his opinions based on the juvenile's behaviors exhibited. The court in both cases found that this was not lay witness testimony, this was expert testimony. The officer, any sort of testimony about metabolized odor having to do with how much a person drank or time period, an officer only would know this because of their experience, wet labs, things of that nature. An ordinary person doesn't have this knowledge. With the same way with the witness's body language, even though this one, and this is a Court of Appeals case, I'm not sure I completely agree with the outcome in this case because I think testimony about body language often can be lay witness. Seeing somebody like drop their head or something like that, many of us as average people may draw our own interpretations over honesty and things like that based on body language. So this one is a much closer line. And it's unclear if cert is going to be sought in this case yet or not. But as of right now, the Court of Appeals has found that his interpretation of the juvenile's body language should have been expert testimony.
And usually, this didn't surprise me because usually witnesses are not allowed to opine on truthfulness or whether they believe what someone said. That's usually an inappropriate opinion. And not
the concurrence in this case noted that actually that they should have stopped at just the truthfulness piece of it.
Right. So this result did not surprise me at all because normally courts aren't going to allow that type of opinion, not just from an officer, but from anyone, regardless of that. And then, of course, one of the hallmarks about when someone has to be endorsed as an expert, then they can have a Schreck hearing. And at a Schreck hearing, one of the things is this thing reasonably based upon science? And so the metabolized alcohol odor and its association with drinks, that would have to be tested. And the question is, how reasonably accurate is that? Is that something that you guys have heard about or have familiarity with? And it took me by surprise as well. And then likewise, in terms of basing an opinion on as to credibility based on body language is something that might have to be established by reasonable scientific measures because I think there's a great deal of disagreement in that regard. So those are one of the undercurrents in terms of what would be involved if this was qualified as an expert.
Yep, certainly. Be interesting to see what happens. And those are our 3 expert witness cases. And that is it, guys.